Hello, 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 amazing law nerd. I had just a little bit of a tech hiccup at the beginning here, so hopefully we are live because we've just got a little bit of a hiccup. So, how are y'all doing today? Today, we are back in Utah in court, and that is going to be very interesting. Because we are here. If you have not watched Secret Lives of Mormon Wives, don't worry. If you have, I've got you. If you're like, what is this, Dakota Taylor? What is happening? I've got you. And I'm going to do a quick breakdown of what they are in court for today before we fly to Salt Lake City. So we're flying into Salt Lake City. Some of you are like, I know everything that is going on here. And some of you are like, I don't know who anyone is, but I'm here anyway because let's see what's going on. So, law nerds, are you ready? Are you ready? I'm ready. I hope you're ready. We're ready. We're going to roll. We are going to do a quick breakdown of what's happening, and then we are going to go to court, and then we are going to answer questions. For those of you who don't know what this case is about, it is a protective order case with allegations of domestic violence. I do not know if they're going to be getting into factual findings today. We might not, but just in case they do, I wanted to give you the heads up on that because that's what the hearing is for. But we have not covered a protective order hearing together in a non-criminal case. This is a civil protective order hearing that was filed by Dakota against Taylor. We're going to go through it. Let's roll the intro. We've got a new soundboard today, so the tech is gonna tech. We're gonna go to Utah. It's all gonna be all good. We're gonna figure out things on the back end. It's just gonna be fine. It's gonna be fine. It's all going to be fine. Everything's fine. It's fine. So cheers, law nerd. Let me know where you're coming in from, what you're drinking. I've got a whole bunch of water, and we're going to be in a different court in Utah. Look at us. Salt Lake City, here we come. So let's roll the intro, and let's get into it. Good to see you, law nerds. Happy Tuesday. If I didn't do a date check, I don't know if I did. It's Tuesday. It's April 7th. We've got a lot to do today. So let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right, law nerds, if you're like, what are we doing? All right, let's take a quick moment, talk about who everybody is. We are going to Salt Lake City, Utah for a civil restraining order hearing. This civil restraining order was filed by Dakota Mortenson against Taylor Frankie Paul. If you saw my podcast episode about The Bachelorette getting canceled, the Bachelorette was supposed to be Taylor Frankie Paul. She is a TikToker. She was involved and exposed a swinging scandal amongst her friend group, and that, it seemed, was what made Hulu go, you know what we need? We need an entire show. Grab cameras, grab everybody, let's do it. And so that is where Secret Lives of Mormon Wives picked up cameras and was like, swinging scandal, let's go. And I'm not, if you have questions about the swinging scandal, that's probably for another day. But not soaking, partner swapping that ended up with everybody's marriages ending in divorce. So Taylor Frankie Paul went on TikTok and exposed the entire swinging scandal. Secret Lives of Mormon Wives picks up cameras, decides we need an entire TV show about this, grab a swig, let's go. And then production got paused because between Taylor Frankie Paul and her then new boyfriend, Dakota Mortenson, there was a DV incident that resulted in Taylor being arrested, prosecuted, taking a plea deal, and being on probation. She is currently still on probation. She is on essentially a deferred entry, a plea in abeyance, if you will. And that means that if she stays out of trouble, the felony assault does not go on her record. However, if there are additional problems or incidents, then that felony can end up on her record. She has that open criminal probation case that is not done until August 2026. So in that case, Taylor was prosecuted, Dakota being the victim in that case. But also when cameras picked up, Taylor was pregnant with Dakota's child. So they now have a young child in common. Taylor has children from a prior marriage as well. So that prior incident was much discussed running up to The Bachelorette because apparently, or allegedly, when Taylor got back from filming The Bachelorette, there were additional incidents between her and Dakota. And that was all getting shared with TMZ. And then right before The Bachelorette was set to air, I believe that Dakota shared the video of the DV incidents that the subject of the 2023 case with TMZ. I have a whole podcast. I talk about it. I think he gave it to them or sold it to them. Either way, that video came to light. Again, reading a police report is a lot different and a lot less visceral for the public than seeing a video. I'm not going to play the video. It is well out there on the internet. It's a choice if you want to watch it, but it is a DV incident. There is a child involved in that incident who was hit by essentially a thrown bar stool that was deflected. And there has been a lot of conversation about that video, but that is from the prior incident. So Taylor and Dakota were recording together. Emily, that's a terrible idea. Yeah, it is. Yeah, it is. Yeah, that's a terrible idea. But they were recording together running up to her leaving to go film on The Bachelorette. And that is where season 4 of Secret Lives of Mormon Wives ends, with her leaving to go film The Bachelorette, clearly not in a good place. She is distraught, distressed, and seemingly not wanting to go film, and everyone is pushing her to go film. This is what I observed. Opinions may vary. This is what I observed. And they kept they kept filming together. So there was not a protective order. Emily, they're back in court for a protective order. Yeah, there wasn't one on the criminal case because they were still filming together, which is a terrible idea. It is so toxic. But either way, I'm not production, so I don't get to make that choice. So she leaves to go film The Bachelorette, films The Bachelorette, gets back from filming, and there are additional instances between her and Dakota. Both of them make allegations against one another. It is that series of events now, March 2026, end of February, beginning of March 2026, that is the subject of the protective order that we are going to see. There are other legal things going on, a lot of them sealed, but there is still custody stuff going on with Taylor and her ex-husband regarding their kids. There is custody stuff going on with Taylor and Dakota regarding their child. There is a protective order that Dakota filed against Taylor and more. So there are allegations back and forth and a protective order. When that temporary protective order was issued, as they get issued on a very low standard, because the goal of a temporary protective order is to stop what's happening and protect the person that needs protection. In Utah, one of the things that is standard on their protective order, and this will vary by jurisdiction, but one of the things on their protective order is that you can click custody and custody can automatically be determined during that temporary protective order. And that's what was done here. We saw a lot of headlines about Taylor losing custody. That's a really broad oversimplification. Temporary custody was awarded to Dakota because of the temporary restraining order. It does not permanently change a custody arrangement. It is a temporary custody arrangement. So in that custody arrangement, That will last until the temporary restraining order is resolved, until another arrangement is made, or what have you. So with all of that circumstance, they are in a hearing today regarding the temporary protective order. It has not been heard on the facts of the case. It has been filed. So the TRO was filed, it was granted temporarily, and then hearings were set. Today is one of those hearings. Remember, getting a TRO, very low bar. The goal is to stop whatever situation is happening, protect the person who needs protection, and then sort it out. That is the goal of the temporary protective order or the temporary restraining order, depending on jurisdiction. I will use them synonymously. So when we go into this hearing today, they also have a hearing coming up at the end of the month. So they have not yet had a hearing on the facts to determine what's going to happen next. This is going to be, well, we'll see. I'm not sure what they're going to accomplish at the hearing today. We're going to have to go to court and find out. Most of the documents in this case are sealed. So, except the ones that TMZ magically had. Emily, you have very strong opinions about that. Yeah, I do. TMZ magically had some of the sealed documents. You know how I feel about that. It was all in the podcast episode. But except for the documents TMZ had that were filed by Dakota, all of the documents filed by Taylor, Frankie, Paul have not seen the light of day. They are all sealed. So with all of that context, that is what we are in today. Regarding the incidents after The Bachelorette was filmed, there have been no criminal charges filed at this point. However, Draper police indicated that there is an investigation going on. So will there be criminal charges filed? I don't know. Will there be a probation violation filed in the open case for Taylor? That's possible. I have not seen that yet. I've been keeping an eye on it. So when we go to court today, we're going to see what happens. Yeah, we're back in Draper. I've heard nothing about the Maverick. But we're back in Draper. So we're going to go back in Draper. We're going to go back to Draper. No, today we're in Salt Lake City at the courthouse. But yes, Snarktastic Sam said another caper in Draper. Yes. I have a lot of thoughts about this. Here's my overwhelming thought for Emily. Why are we just jumping into a TRO hearing for today? Here's why. There are going to be a lot of headlines after this, and not all of them are going to be right. And so we're going to be in the courtroom where it happened. We're just going to be in the courtroom where it happened together. We're going to watch it happen in court. There is a pool camera. There is also the ability to stream the WebEx, which we are also saving. So we've got both options. What's going to happen? I don't know. We're going to find out. So if you are ready to jump into a case where you either know a whole lot about this case or you know absolutely nothing about this case, either way, we have not really gone through a civil TRO hearing. And then I'm going to save all of your questions about that for after the hearing. Some of them I think will be answered during the hearing. So that's what we're going to do today. And we're going to see what happens. Good to see you, law nerds. Hopefully that summary was helpful. We're having some tech issues on my end. So when we start court, you're going to see my eyes doing all of that stuff. Look, here's what I am hoping to accomplish today. I am hoping that we understand the legal standing and positioning of this case. The wildness between the two parties is not what I am here to sort out today. I don't have enough information. I don't think we all have enough information to sort out everything going on between Dakota and Taylor, because with the most recent incidents, we only have a part of one side of the story. What I have determined for myself by watching this unfold on Secret Lives of Mormon Wives is that the two of them shouldn't be filming together. Those two are going to have to figure out how to co-parent and not really interact with each other for a bit. Those two do not do well in the same space with each other at all. Nope. So that is where I'm at. The two of them need to just be in separate spots. And the reason that criminal case didn't have a protective order, I believe, is so they could film. And the question I have constantly is, A, I wish the court would have put their foot down, but B, how do you take two individuals whose money is tied up in their interactions together and try to stop that cycle from happening? I don't know the answer to that, other than at some point production needs to be like, hey, this is a dangerous situation for both parties and the children, so we need to not have them filmed together. And they probably should have made that decision back in 2023, but they didn't. However, the other women on Secret Lives of Mormon Wives this year have said, we're not filming season 5, and cameras were down. So season 5 started filming and then stopped. So we'll see what happens. But I have thoughts. I don't know, man. We'll see. It's one of those things where I'm like, do we give it more oxygen because it's real toxic? Well, that's an issue. However, if we don't stream court, because there's cameras in court today, if we don't stream court, then there's just going to be wrong information. And that's annoying too. So let's go to court and see what happens. And of course, we have to ask the question all of you have asked in the chat, including Lone Wolf, will Mom Talk survive this? Look, as long as Dad Talk doesn't survive it, I think that at some point, the participants in the show need to protect themselves and not worry about production as much. I think they need a break. I think everybody needs a break. I think everyone needs a break. Yeah. For those of you asking, what is Mom Talk? Mom Talk is the group of women that self-references Mom Talk throughout the Secret Lives of Mormon Wives show, which was in the first few seasons, you're just like, this is interesting. And then as it goes on, you're like, wow, this is all real toxic behavior. Yeah, this is toxic. Hopefully we can get to the, we can get to the heart of what's happening in court today. We're not going to get to the heart of what's happening between these parties. But I imagine custody will come up. I don't know if we will get into too much of the facts of the case, but if we do, just a warning as we're going to fly to Utah now, but just this is a case where they are going to be talking about shared children and instances of domestic violence, the new instances that have been alleged. We have seen from Dakota's perspective through documents TMZ had. Both of them have made allegations against the other. I don't know how many facts of those we will hear today, but just a heads up. And we're going to go to court. So let's get your Sky Miles and let's go. Let's go to court. That's not the right camera. That's not the right court feed. That's not the right one. We're going to bibbity bobbity court. Yay! Court. Let's get started. Well, let's try to get started because we had to talk about the case just a little bit. Let's see. The courtroom looks exactly the same as Judge M's. It's not the same courtroom. It's not the same courtroom at all. It is in Salt Lake City, not in Park City. Let's zoom a little till the judge gets on the bench. I thought we were close. There we go.
If you're going to be on a laptop, if you have notifications, please silence those so you don't get interrupted with any notification sounds. I'm going to go get the commissioner. Thank you.
All right, so they're going to go get the judge or the commissioner. It's just a different designation. Everybody, of course, silence your cell phones.
All right.
I know, it's really weird. State of Utah, not Judge M. I don't know what to do with that either, y'all. I don't. I'm sorry, Commissioner.
All right, one moment, please.
But not Judge M. So, is what it is. And then we will see once the mics pick up. Hopefully the sound is good. I imagine the judge is starting the WebEx feed. The parties.
Now calling the matter of
Emily, you said you hoped the sound guy. I did. Hopefully you guys can hear it.
Mortenson and Taylor Frankie Paul, case number 26490.
How's sound for y'all?
1444. Council appearances, please.
Daniela Diaz on behalf of the petitioner, Dakota Mortenson.
Okay.
Morning, Your Honor. Eric Swinard and Ryan Ficklin for the respondent, Taylor Paul. She's appearing via WebEx.
Yeah, the parties are there. It's really low. Yeah, both parties are there via WebEx. I will work on trying to gain it up a little bit.
All right, let me get the...
There's also a guardian ad litem present representing the interest of the child.
WebEx up for me. All right. So just let me recap. We had a conference last week. We talked about continuing the hearing on the merits till April 30th. And today we were going to discuss parent time pending the next hearing. Am I getting that right?
Yes.
All right.
Okay. So as we talked about when we started, they have not yet had a hearing on the merits. They are going to have a hearing on the merits on April 30th. Today, they are going to talk about custody time. Remember when the TRO got filed, Dakota temporarily got 100% custody. That is not what their custody case has said thus far, but they are in the middle of a custody case. So when they talk about the hearing on the merits, they are going to talk about whether the temporary restraining order needs to become a permanent restraining order of some sort.
All right. Any resolution before we go further?
No resolution. There are a couple housekeeping items, though,
Okay.
Your Honor.
All right.
The parties have reached, as I understand it, a stipulation through counsel that all video evidence would be reviewed in chambers rather than in the courtroom.
That makes sense.
To the extent that may be more of a note in
That's not gonna be
preparation for the
today,
30th
though.
as opposed to today. I don't know what, if any.
Only video that I have was the thumb drive.
Yeah, they're not gonna do that
I think
today.
I received from
That's from the
Dakota.
petitioner. There have been no videos submitted by the respondent thus
Okay.
far.
All right, but I did see that there were documents yesterday, I think it was yesterday by Dakota, maybe a little earlier, and then today from Taylor.
That's
right?
correct. I believe Dakota filed his
And those are all sealed.
large dump of exhibits on Thursday, and Mr. McDonald filed a handful of exhibits on behalf of the Guardian Ad Litem office yesterday.
I did see the Guardian's exhibits as well,
And Your Honor,
which
just
was
to
largely
clarify-
related, I think, to the former criminal matter. Okay.
And Your Honor, just to clarify, what was filed by Dakota yesterday was a correction on the exhibit list that was
I did
previously
see that as
filed,
well.
but
Back up.
The date was corrected on
It was
Exhibit
just a
7.
description changed, right?
Yes.
Okay. All right.
So my
Yeah, they gained up the microphones in court. They just gained up the microphones in court.
office, we filed our exhibits for today about an hour or two ago.
I saw that.
And importantly, we did also file a request for a protective order on behalf of my client about an hour ago. Figured we'd update
When is
the-
that, is there a temporary order on that yet? Has that gone through?
Not that I'm aware of. It's
Okay.
pretty hot off the.
Are you going to say hot off the presses? Okay, so we're going to have cross protective orders now. So Dakota filed a protective order and Taylor is now filing a protective order. He's literally going to say hot off the presses.
Just to clarify, what was filed by Dakota yesterday was a correction on the exhibit list that was
I did
previously
see that as
filed,
well.
but a date was corrected on
It was
Exhibit
just a
7.
description changed, right?
Yes.
Okay. All right.
So my office, we filed our exhibits for today about an hour or two ago.
I saw that.
And importantly, we did also file a request for a protective order on behalf of my client about an hour ago. Figured we'd update
When is that, is there a temporary order on that?
That is Taylor's lawyer. So there's not going to be a temporary order on that just yet.
Yet? Has that gone through?
Not that I'm aware of. It's
Okay.
pretty hot off the presses.
All right. So that'll
I mean, does
go
TMZ have
through
it?
Commissioner Olson. He screens those,
Okay.
makes the determination as to whether the temporary order will issue on.
The commissioner's last name is Minus? Well, Commissioner M. All right. Judge M and Commissioner M. Okay. Hello, Commissioner M.
That. And then, given that I guess I'm assuming that even if that were denied, you'd want a hearing on that as well.
Of course.
Okay. So maybe we can schedule that for the same time on the 28th, was it on the
30th.
30th of April?
So
That's
there are
why I
going
brought
to
it up
be
now, because
cross
that might be the
complaint.
easiest way to address that, have a showdown on the
Okay.
30th.
All right. So,
Counsel, I know it's hard when you are used to lawyer talk. This gets me too. When you are used to speaking freely with the court and not with an audience, there's just different vernacular. But I don't know if a showdown is helpful to us. I don't know if that's helpful to us.
hopefully it won't be a showdown. I'm hoping that you actually can come to some resolution, but.
That would be fine, too.
Any
Thank
issues
you,
with that, maybe scheduling. I do have a regular protective order calendar. I've been trying to keep this matter off of that so that I didn't have issues with trying to manage those other matters that might be difficult to manage if this case is also on the regular protective order calendar.
That's fair.
Your Honor,
We're going to be here anyway.
Yeah,
I'm gonna go
I'll
look
leave
for
it
that
to
other
the
case.
discretion of the court. The only thing at this point, that we really just want to make sure that, and I mean, this would have had to have been disclosed in the other protective order, that this case is existing for the purposes
Obviously.
of, custody orders, and that being combined to one case so that, we just have one case looking at custody.
It'll still be two cases. I think since it's the same incident, I typically, when I have competing protective order requests,
You
I'll just
come
call them
together.
both at the same time. All
That
right.
would be fine, Your Honor.
And this case was disclosed in the new one, just to address counsel's concerns.
Right, and they're very careful, Commissioner Olson is very careful not to issue competing custody orders that might lead to chaos reigning. We don't want that to happen either.
No, we don't.
All right, I do have one question too before we begin, going back to the initial petition. And when I looked at the allegations, the way it was described, Dakota was pro se, I believe, when he filed this.
That means he was representing himself. You can go online and file these, so I wouldn't be surprised if that's what happened here.
I don't think he listed having an attorney at that time. But it said he listed the most recent incident as February 23rd and February 24th of 2025. I'm thinking that was a typo. And
That has to be a typo,
Because that
yes.
changes the analysis a little
Yes.
bit. Okay.
Yes, Your Honor, that was a typo. The most recent incident would have been February 23rd and 24th of 2026.
Okay. Any other preliminary matters before we get into the merits on parent time?
Not that I'm aware of.
Okay.
Your Honor, the videos that were submitted by Petitioner, were you able to watch those?
I did. Yeah. Okay. All right. Very good then. Then I believe,
Petitioner is Dakota in this case. Respondent is Taylor Frankie Paul. So when they are asking about if you reviewed the videos, those would be videos from Dakota submitting them to determine parent time. So when they talk about the merits, they are not deciding the entire universe of whether this temporary protective order becomes a permanent form of a protective order or a longer form of a protective order. They are just trying to determine parenting time because when this initial order was filed and signed, temporary full custody went to Dakota, and they are trying to sort that out now.
well, I should say, Ms. Diaz, you're the petitioner's counsel on this, so I think you'd be up first.
And Petitioner is Dakota.
Yes, Your Honor. So as you already outlined today, we're just trying to look at what types of custody modifications can be made to this order before we all meet again on the 30th.
Okay.
I guess we'll be back here on the
given
30th.
the evidence that's been submitted in this case, the allegations in the petition, we would like to see visitation be supervised, and we'd like to see it preferably by a facility. that can act as a go-between between the parties. We do not believe that it would be safe for my client, for the parties to
Her client's
communicate directly
Dakota.
with each other about this. It's also my understanding there aren't really any other options at this point either. And based on the evidence that has been submitted here, I think it's appropriate for safety, given that this is a DV case.
Can I ask one question about this? I even before it was filed with the court, I'd been reviewing, I'm also assigned to the domestic matter.
Okay.
So I did notice that even after the allegations that led to the criminal charges in 2023, they had come to a resolution. They settled their custody case.
Yes, they did.
And I'm gathering this kind of maybe blows that up to a degree, but
Wonderful.
how do you,
So my understanding with the
reconcile
custody
that?
case is that a resolution was reached and a stipulation was signed.
Never
but
entered.
It was never entered. There still haven't been financial documents submitted, I believe, by the respondent on that case.
Respondent is Taylor Frankie Paul. Petitioner is Dakota. This is a civil restraining order. There is also a custody case that is pending. There is a guardian ad litem attorney present, and the guardian ad litem attorney represents the interest of the child. So instead of either parent advocating for the child, the guardian ad litem is there to advocate for the child. So I imagine we will hear from the lawyer for Dakota, for Taylor, like for the dad, for the mom, and then for the child.
Well, sorry, Mrs. Paul, it hasn't submitted them, and so that's why it hasn't been entered. And so, I think that the very nature of a protective order is right. Like these things could still be negotiated and dealt with in the custody case, and another agreement could be reached. It hasn't technically been entered, but even if it had, it could have been modified. So.
Let me ask this too. Is he alleging that she's ever done anything that was aimed at the children, directly at the children, or
I
it
don't
was
think he is.
incidental, her actions towards him that where the children happened to be present, or one or more child happened to be present?
Your Honor, we're alleging both. That
Really?
In the moments where the respondent is out of control, and in these moments where the parties are fighting and she is completely out of control, both things happen. She is completely reckless in her behavior towards the children. So yes, if they happen to be in the line of fire when she's coming at him, yes, they will get harmed. I'll draw the court's attention actually to our Exhibit 8, in which my client was holding, their young child.
Well, my question is really more where the anger was directed.
Right.
And we believe also that this is a case that as we look.
She is not answering the judge's question because we see what the judge is. You can see what the judge is signaling, and it's like, counsel, is this directed at the children or is this directed at your client? Because it seems like the fighting is between Taylor and Dakota. Yes, it happens when the children are around, but that's what the court is trying to get at, and she is sidestepping that.
Look deeper and deeper into the evidence, that you'll see that there's a lot of sort of coercive control happening, and that does involve sometimes.
That's a bold argument, counsel.
Like acting violently around or towards or slamming the doors of the child's room, trying to disrupt and involve the child in the violence in order to get my client to react.
Okay. All right. Let's hear the response, and then I'll go to the guardian ad litem. We'll work our way back to the petitioner.
Great. So you want to?
Yeah, because she didn't answer. The court's like, great. We'll come back. Yeah, we'll come back to it.
Us to go now, Your Honor.
Please.
Can I approach?
You can.
Why?
Anything you're handing me that hasn't already been provided?
Is that
It's already
you?
been provided to counsel?
Yeah, exactly. Filed with the court. Counsel has courtesy copies of it. So maybe you need that,
Probably
maybe you
reviewed it
don't.
already. Okay.
Wanted to draw the court's attention to a few different aspects of this case.
We are now moving to the response to that as they are trying to determine the custody issue for Taylor's attorney. So that is the attorney that we are moving to now before we hear from the guardian ad litem.
Requesting today that the parties return to the status quo as outlined in their August 2025 settlement agreement in the custody action. There is a little bit of procedural backstory here that's important for the court to take note of, as well as understanding the substance of the allegations against my client.
I don't know if they're going to talk
I am
about that
concerned,
more.
and I think the court should be concerned about the lack of credibility of Mr. Mortenson.
Well, there's that.
I understand that today is not the, you bristled when I used the word showdown, so I'm not going to use that again. I know that
Good.
today is not the
The court wasn't the only one who bristled when you used the word showdown. It's family court. They would really like the parties to come to an agreement. However, and I think counsel's already like, it's going to be gloves off. So there we go.
final protective order hearing that's tentatively set for the 30th. But we do have to, I think, dip our toes into the water a little bit to understand the dynamics here between these parties. Then I'll end my argument by looking at the statute, because I just don't know that it automatically triggers supervised parent time for my client in this particular case. The provisions of the temporary protective order that give us heartburn, to put it mildly, would be paragraphs 15 through 17. This is a total suspension of my client's interactions, contact with their 2-year-old son.
I'll add that ex parte order is exactly that. It was
That's why they're
made
here
without
today, though.
your client having been given yet the opportunity to be heard.
That's why we're here today.
My point in bringing this up, it's obviously not unheard of. We see this in certain cases, and in certain cases it is appropriate. Makes no sense here, and I think it speaks to how vindictive Mr. Mortenson is.
He's not asking for today, at least for suspension of parent time, right? He's asking for supervision.
We
That's
learned that.
correct.
We learned that today. You're correct.
Okay.
Also important to note in this case, Your Honor, that he has not actually asked for supervision in his pleadings, but I'll come back to that in a moment.
That's actually,
These parties-
counsel, can we stay on that? That's a good argument. That's a good argument that supervision wasn't asked for on the pleading. What does the guardian ad litem want? Also, that's a very good point. You were better there.
Very small background here, Your Honor. These parties' relationship began in, I believe, 2022. Could have been 2023. The child, their 2-year-old son, was born March 19th, 2024, which maybe this is a coincidence, maybe it's not, but March 19th is the same day that Mr. Mortenson chose to file his protective order against our client. I'll say
Only on the same day the video found its way to TMZ, but you know.
something very uncontroversial, and that is that these folks have had a tumultuous relationship. Lots of fighting. This course over the course of today's hearing, as well as the next few weeks, we'll see that both sides have a lot of allegations against the other that are going to be lobbed against the other in this case and in the new protective order filing. Mr. Morton.
Yeah, there's a lot of allegations. I think this is the first time that court is a bit too loud, chat. So, we'll try to balance it. But Lord, we're not here on the merits of the protective order. Parenting time. You are better at status quo. Status quo is good. The courts like status quo. Your status quo argument is stronger.
As the court pointed out, filed a custody action on June 25th of last year, and that case was settled August 22nd of last year. I think those dates are pretty important because, as the court already indicated, 8 of the 11 exhibits submitted by Mr. Mortenson predate his settlement agreement, which again I think calls into question, not absolutely, but I think it would call into question the relevance of these exhibits for purposes of custody and supervision.
Where I think it comes into play is
That's
that
really interesting.
the statute specifically states that the passage of time per se cannot be the only basis for denying the request for a protective order. Certainly, I consider whether there may be ulterior motives, like trying to gain a leg up in a custody dispute, right?
Right.
Yeah.
Nope,
Always a concern.
I'm with you, Your Honor. Importantly, in the custody case, he didn't ask for supervision there at any stage that I'm aware of.
I mean, counsel, these incidents happened after that, though. If there are continuing instances of domestic violence, then it changes the status quo versus a year plus from them. So,
And like I mentioned, they said
Before the February incident.
yeah, but also after 8 of the 11 incidents. And you know,
11?
I'm excited to talk about February because I think that is critically important to look at today.
11?
So we'll get there in just a moment.
we're backing up for that. Also, because this is not a trial, because this is not even close to anything like that, it is a civil protective order hearing. There is one camera in the courtroom, and that camera is behind this attorney. So there is that.
Importantly, in the custody case, he didn't ask for supervision there at any stage that I'm aware of. And like I mentioned, they said
Before the February incident.
yeah, but also after 8 of the 11 incidents. And, you know, I'm excited to talk about February because I think that is critically important to look at today. So we'll get there in just a moment. This was settled August 22nd. Both had lawyers. Mr. Mortenson was represented by Mr. Hansen. Taylor was represented by our office with Mr. Ficklin running point on the case. And the result of that settlement is Taylor has custody of this child. It's roughly a 70-30 division. It's mathematically.
It was 20 of 28 days over a 4-week schedule for her overnights.
Yep. There you go. You've read it. You've done your homework. Appreciate that.
Bro, don't patronize the court when the court's on your side. Counsel's talking a little bit fast, and everyone has the papers to look at except for us because they are sealed. So he is talking about 8 of 11 incidents happened prior to the custody agreement being reached. And then we have the 2 from February. So 8 of 11 incidents that they are talking about happened before the August custody agreement was reached. 2 happened after that incident, or 2 happened after the custody agreement was reached. So that's where we're at on the timing of that. But like, why are we condescending the judge?
So that, again, I think that this procedural backstory does call into question the necessity of supervision at this stage. Also, transitioning in my argument at this point.
Before you go there, let me just ask. We don't have video, do we, of the February incident at all, right? Everything
given
that
me
I've
video.
seen is the aftermath.
Right.
People talking to
Correct.
each other, recorded text messages that happened after the fact. For this February incident, I don't think there's any video evidence. So at least I haven't seen it yet.
That's my understanding, and I don't believe Mr. Mortenson has provided anything related to February.
Okay. All
Either
right.
party.
All right.
And that's
And
your
what is
second
the
question about
status of the
February, so I'm
police
skipping ahead to February because I think that is obviously important for the case, and I can come back.
Counsel, I am a commentator. You are not. Let the court finish. Counsel, let the court finish. Just let the court finish.
Back to a couple things
All right.
that I also think are important for the court. As for February, this is a perfect data point in this case to evaluate Mr. Mortenson's credibility or the lack of credibility, as is the case here. And I understand Mr. McDonald will want to talk about 2023. Mr. Mortenson will, of course, want to talk about the 2023 incident, the well-publicized 2023 incident. Mr. Mortenson has already raised the 2025 incident. I get that, and we can have a separate discussion about each of those. I want something very recent, very fresh for this court to evaluate in terms of looking at the party's conduct.
Okay.
And February, we are one day off, by the way. So Mr. Mortenson, in his request for a protective order, alleged that these events took place on the 23rd and 24th.
Is it material?
No, but I'm just clarifying because each party may reference different dates but the same events, so I wanted you to understand.
Okay.
The
All right.
events, as my client understands it, took place the very early morning hours, about 6 a.m. or so, of Sunday, February 22nd, and then the following day after midnight on the 23rd. So 2 separate incidents, 2 separate interactions, and I'm looking at, for purposes of today, I'm looking at the 23rd, or what I call the truck tussle. Essentially, both parties
Not a
alleged
name.
that they were having that Dakota came over to Taylor's house
I
to,
think was most of the incidents, right? Where she lived. I'm trying to go through that, but that's okay. You keep going. Keep going.
yeah. So essentially, they've had, obviously, a tumultuous relationship, and there's been
Clearly.
a very well-documented history of Dakota trying to re-engage and re-enter and resume the relationship. And one such example took place on February 23rd of this year, early morning hours, soon after midnight.
Before the violent episode, right? Before the incident.
Yeah,
Yeah.
this is that incident, the truck tussle. So kids are sleeping inside, the 3 children that my client has, 2 with her ex-husband and 1 with Mr. Mortenson. They're sleeping inside her home in Draper. Mr. Mortenson comes over, and my client decides, fine,
Why did he come over?
talk about the relationship.
Not to pick up the kids? It wasn't
No,
his turn?
no,
to
middle
have
of the
kid
night. It wasn't related to
Invited
the
over,
children.
or did he just show up with unannounced?
I think it was by invitation. In other words, she
Okay.
acquiesced to his coming over.
Okay, all right.
Kids are sleeping. She doesn't want it to escalate and turn into an argument, so she says, fine, I'll talk, but let's do it in your truck. So they go in and they sit in the front seat of the truck, and things immediately start to escalate. He drives away with her in the truck against her objection, and then something happens, okay? I say something because this is where there's a
Camera, can we just go back to the speaker? We know that their names are on Zoom. They're on Zoom. For all of you asking, why can't they just unmute them and ask them? Because they are not in person. They are not on the stand. They are not testifying. This is argument from the attorneys. But also, if your 3 kids are sleeping, don't drive off.
huge divergence in the stories. You've read the request for protective orders supplied by Mr. Mortenson. He says, Taylor went crazy and she threw a drink and I don't know. She assaulted him, essentially at its core. Taylor alleges that he grabbed her head during the course of this argument
So I guess we are getting to
and
this.
slammed it into the dashboard.
Facts
And
in this case.
in the ensuing chaos, also struck with his fist, her knee, and her elbow. In that binder in front of you, Your Honor, you'll see exhibits E and F. E shows the progression of a bruise on her forehead that she took,
Kind of yellowish in the picture.
gets yellow.
Can they just go focus back on the lawyers? Like, Dakota's name is on Zoom. Why are we focusing on the Zoom screen?
Yeah, the first one was taken hours after the incident, so not really yellow, but it's discolored. There's a bump. And then the additional pictures within that exhibit show the progression, how the color changes of the bruise. Exhibit F shows something similar. It's a bruise on her knee from when he struck her in the truck. My client would testify
Who took
that
the photos? What's the foundation?
my client took the photos.
On the day of the incident?
The first one was taken, I believe, within hours, so think under 10 hours or so after the incident when the bruise formed.
Were these photos provided to law enforcement?
I don't know what photos were provided to law enforcement, Your Honor.
Right. You don't know whether they took their own photos?
I am not aware of that.
And we don't have
Law enforcement was
we don't have a
contacted.
report yet.
Is there a
right,
police
on
report?
No,
that incident.
no. All I've
there's-
heard from Draper City is that they do not intend to pursue charges against either party.
Really?
But
Okay.
nothing's really set in stone.
That's new information. So Draper police are saying that they are not pursuing charges against either party?
They do not intend to pursue charges.
That's new information. I wonder if they are going to pursue it as a violation of her probation, though.
No,
That incident.
no. All I've heard from Draper City is that they do not intend to pursue charges against either party. But
Okay.
nothing's really set in stone
Haven't written a
until.
letter to that effect, or
Nope. So all I can tell you is through the grapevine. So not very.
you should get a report in any event,
Yeah.
right?
I'm going to spare you my rant about.
I'm going to spare everyone my rant about the camera work. If you're listening in the background, you are blessed. Stay where you're at. I they should get a report. And then the DA's office should also send a intent not to file.
About getting police reports.
I
Yes, I
know
agree.
about the problems with the grammar requests and the delay. I'm referring to there ought to be a report at some point, I would think, right?
Yes, but in
Are we recording B-roll or a hearing?
unredacted report has not been released.
Okay, all right.
So getting back to this, so both parties essentially at their core, and you'll see in my client's request for a protective order that was filed today, you will eventually see
I'm gonna go
line
look
by
for that.
line her detail of events that took
I mean,
place
I'm sure
in the
it's
truck.
sealed, but I'm gonna go
You've
look
seen
for
in
that.
Dakota's request for protective order, it's a bit muddled, but
I haven't read her request.
I understand. Not holding you to
I
that.
didn't even know it
Filed.
existed until I came into
Yep.
the courtroom. Okay.
Exactly.
fundamentally, both
didn't
parties
see it last
alleged
night.
that they were the
Just did it
primary
today.
aggressor of a tussle in the truck, and that constitutes assault and a violent act by the other party, and therefore should be part of the basis for a protective order. No one was in that truck but them. What I think is very important is to look at their conduct in the immediate aftermath. I would think, if I'm Dakota in this scenario, what would I do? I would get the heck away from that woman. If we believe his request for a protective order, why would he be in the same room as her? He would need to get as far away from her as he possibly could.
How long have they been separated?
Well,
Not-
their relationship.
Excuse me, Your Honor. They were still having sex up until the day she left to film for The Bachelorette. They're not separated. They are not separated.
Live together.
Sorry, what, Your Honor?
They ever lived together? And if so, when did they separate?
I'm not aware if they ever lived together.
All right, okay.
But they have not been they have not actually maintained a relationship for several months, as my client would define it.
Well, they have a child in common. They have to have continuous interaction with each other in some form.
a traditional
for the remainder of
committed,
the minority of their child.
a traditional committed romantic relationship. They've not been engaged in that for quite some time.
They are still engaged with each other, however.
So that's what Dakota would have done if he were victimized by.
Can we, counsel, can we not
Taylor. Get away from this person, right? Now, similarly, if you're Taylor,
get away from this
if
person?
you're in her shoes and you're assaulted
All
in his
of you
truck,
get away.
you would demand to be taken home. You'd lock the front door, throw away the key, and you'd say, "Get away from me." That is exactly what she did in the immediate aftermath of the attack. It was Taylor who demanded separation, who demanded that he leave her alone, leave her property, go away. He does not do any of those things. I think, Your Honor, that our Exhibit G is very telling. Exhibit G is a text thread between these parties in the minutes after this supposed attack, the truck tussle. He finally relents, drops her off.
Are you saying supposed attack is to him or is to her? Because she's saying that she was kidnapped in some part or falsely imprisoned and attacked. And he is, whom are we talking about, counsel?
At her Draper home, but he sticks around. Why does he stick around? Well, we would argue he sticks around because he knew he hurt her and he's trying to manage the chaos that's going to ensue from that. What he does is he lingers on her front doorstep. Actually, my client would testify he's physically looking through the window trying to re-engage this conversation.
So is this all about credibility relating to parent time?
It is,
Okay.
because ultimately everything we're looking
Well,
at here is
I have thoughts.
a lot of what we're looking at today relates to his credibility.
I feel like we're getting into the merits of the
Correct.
underlying
You're
claim.
correct.
And I'm almost off
You're correct, Commissioner. That is exactly what is happening right now. That is exactly what's happening. That's 100% what's happening.
this point. But if we look at Exhibit G, he's telling her, open the door, I'll watch the kids, let me help, open the door. And then he just comes right out and says what he's looking for. This supposed victim of domestic violence is looking for sex, plain and simple. He asks her, "Do you want to fuck?" In the immediate aftermath of her supposedly attacking him. That's what he's looking for. That's what he's physically on her doorstep demanding, as documented by these text messages.
What?
So again, Your Honor, I understand we're here with a narrow goal of looking at supervision, but I do think that the court needs to bear in mind the lack of credibility both today as well as at that future hearing. On a couple other arguments.
Counsel? Oh boy. Okay. Well, the court has all the texts. We don't. The court has all the texts.
Related to supervision, Your Honor, it's getting crowded in here in terms of the resources available for these parties.
What do you mean by that?
What I mean by that
100%.
is there's already a substantial network of friends, family members, therapists, even DCFS caseworkers who are assisting.
Well,
My
that answers
client's
that
already
question.
meeting with a therapist. We have no knowledge as to whether Dakota is meeting with a therapist, but might be a good idea. As far as DCFS goes,
Parent time, counsel. You're here to talk about parent time.
both parties are voluntarily engaged with services with DCFS. We met with our client and DCFS yesterday at our firm's South Jordan office
Great.
for a transfer meeting.
Is there some kind of services plan that's in place?
Exactly.
And what is that?
A caseworker's been assigned to help both Dakota and Taylor, and those services are about to commence. In fact, there's already scheduled visits with the caseworker to take place later this week.
Let me ask you.
So then why are we fighting over whether or not there will be supervised visits if there is an ability for there to just be supervised visits for everyone? Maybe we just do that. Maybe we just do that. It sounds like that's already in place. Maybe we just do that till the end of the month. Let's just do that. But yes, chat, to me, it feels like counsel is trying to correct the record a little bit to what's been released to TMZ. This is a different way to do that. Oh, okay. But if there's already services in place, then there we go. There we go. There we go. Let's just do that.
And I'll let you finish. I just wanted to ask,
Focus
before this
the conversation.
February incident, but after the execution of the stipulation in the domestic case, were they acting under the terms of that stipulation in terms of how they were sharing their child?
So from August last year to about February, this is what you're asking. Yes, they did. They implemented that. And I understand one minor point about that, Your Honor. You've already observed that has not been entered in an order, but one of the opening provisions of that settlement agreement is that they agreed to implement this immediately and consider it an enforceable agreement immediately.
Yeah, I anticipate that could be the subject of another motion hearing in the domestic case as to whether or not the court.
I don't know, Chad. I don't know. I don't know what's happening.
Court should find that agreement enforceable.
As far as
I'm going to back up to what the court was saying because I got so distracted by the camera work because it's just, yeah, it's distracting.
And I understand one minor point about that, Your Honor. You've already observed that has not been entered in an order, but one of the opening provisions of that settlement agreement is that they agreed to implement this immediately and consider it an enforceable agreement immediately.
Yeah, I anticipate that could be the subject of another motion hearing in the domestic case as to whether or not the court should find that agreement enforceable.
When the court says the domestic case, he is referring to the custody case. Same. Mm-hmm.
As far as other folks or agencies helping out, there is a guardian ad litem. Both sides have signaled that they'll cooperate. My client has a strong family and support network here in Utah. I'm not aware of Dakota having any. It's my understanding that he's been forced to rely on family members out of state for the last several weeks to watch this child because he doesn't have the network that my client does here. So that's a problem, and I think relevant for supervision purposes. My client simply has the ability to have parent time without overly relying on these third parties. As far as the statute goes, a couple of observations on the statute, Your Honor. Again, supervision was not requested in this case in the both initial request for a
That's
protective
the better
order and the
argument.
amended request for a protective order.
That's a good argument.
I understand this court needs to do what's in the best interest of the child.
Was that, then are you
Yes.
saying that was done sua sponte by the signing commissioner?
I actually don't see any mention of supervision in the temporary protective order either. That it's essentially going to be addressed
Suspended.
today.
I mean, we do often, we just, to keep it clean, we'll just suspend. We know we're having a hearing within a couple weeks, and then we'll deal with it.
To
Okay,
clarify
well,
what I'm
now
talking
they
about, I'm
need
not
to-
talking about the suspension. Dakota did ask for a full suspension of parent time in the request. He did not ask for supervised parent time.
Well, that's more restrictive than supervision,
Correct.
suspension.
I understand. I'm just letting you know that this is something he raised late in the game, so to speak, and we think that there is a prejudicial element to having that entertained today.
Well, counsel, if the court maintains the status quo, that means Taylor has no access to her child. If there's supervision, then she will see her child. So, counsel, they are trying to litigate, including you. I would expect that Taylor wants to see her kid, and so y'all are trying to make that happen. If you maintain the status quo is he has 100% custody right now, and she does not have any.
Okay.
The statute 819207 provides that this court could enter supervision if there's no less restrictive means available. We do think that there are plenty of less restrictive means available to safeguard this child's interest based on what I just articulated. This is clearly within the court's discretion. The court may order supervised parent time, even when a party pleads it, which Dakota did not. It's within the court's discretion.
There's the
Additionally,
standard.
this court would need to enter a supervision order if the court finds that the child will be subject to abuse if left unsupervised.
Well, I guess the one thing I'm concerned about is her volatility, even if he's pushing buttons. Some of the videos suggest that when she finally snaps, there's significance to it. And does that pose a problem for the safety of the children?
Your Honor, you hit it right on the head at the outset of the.
Counsel, we need to just let's not go with idioms or analogies. Let's just keep it simple. Your Honor, the two of them need to be not near each other. There needs to be a third party to facilitate transference of the child. That is all. Absolute stay away order for both of them. Because the court said exactly what it was when the two of them are together. Correct. The two of them stay apart. Third party is the one who transfers the children. That is it. That is it. A third party can do the exchange. That is all. They have to stay apart from each other, completely apart from each other.
Significance to it. And does that pose a problem for the safety of the children?
Your Honor, you hit it right on the head at the outset of the hearing in asking Ms. Diaz the question of where is the anger directed. Dakota is excellent at escalating and aggravating my client, and her, when she reacts, it's 100% directed at Dakota. And any exposure the child would have to that.
I'm not saying it's defensible, but you're answering my question, I guess, is what from earlier, right?
Keep the two of them apart. Yes.
Absolutely. So
Yes.
this is not my
That.
client has she has no risk to these
I
children.
don't know how you can, that reaction, even where the children are present, where children are present, in one instance in his arms, I think. right?
You're talking about the May 2025
Yeah,
incident?
we're going back, a little
Well,
ways, yeah.
I want to address this as well as I can for you. What concerns you about that, Your Honor?
Well, I can have concerns about
The May 2025 incident is not something that we are heretofore aware of. So whatever video the court has is not the video that we have talked about, is not the video from the 2023 incident. So there are 11 incidents between the two of them that the court has before them. 8 of them happened before a custody order was reached. All of the filings regarding this are sealed. The prior criminal case is from 2023, and it sounds like there are numerous other videos. But whatever happened in May 2025, we do not know until we hear it from counsel. This is not the video that became public prior to the Bachelorette getting pulled.
volatility and not reacting in a different way, even if she feels like she's being provoked, when you have a child right there in front of you. And that's my concern there, is that didn't seem to be recognizing that this child was being exposed to that conduct, whereas maybe she could have turned around and walked the other way. I don't know. I wasn't there, of course, but that's one of the concerns that I have from viewing some of the videos.
Yeah, and I'm sure both sides, or at least my client, would prefer to take that one back, right, and redo that one. My comment on May, because I think this will come up, especially when Mr. McDonald speaks, my comment about the May 2025 interaction is it's important to note that's taking place in my client's home, and Dakota started recording only after my client asked multiple times for him to leave. He did not. Even in the video, when the recording starts,
which seems to be consistent, that she asks him to leave and he doesn't.
she tells him, "Get out of my house, Dakota." What does he do? He does not leave. He plants it right in front of her.
And picks up his
he
phone.
says, "No, what you're doing is not okay." He's holding the child as his human shield, so to speak, and provoking my client and not getting out of her house. So
Okay, well, when I said they weren't litigating this on the merits today, and the judge said they weren't litigating this on the merits today, and all of this wasn't being litigated on the merits today, here we are with it being litigated on the merits, I suppose.
this idea that
Well, if that's the case, he got the reaction that he was looking for.
he got the reaction he was looking
I'm
for.
not making a finding about that, but yeah.
They need
Yeah.
to figure out custody, counsel.
The reason I bring this up is Dakota pushes buttons. He's excellent at that. As long as these folks stay apart, which I think is fully stipulated, they need to stay apart. I don't think there's any risk of them coming together again in the aftermath of this. Then there is no risk to the child. No one's going to come into my client's house, whip out.
You're doing better with that argument. You're doing better with the argument that they need to stay apart. A third party needs to assist with custody of the child, and period, until they figure out the rest of it, which sounds like both of them need restraining orders on the other, which is going to make parenting difficult. However, they have to stay apart from each other, period.
out their phone and, and test her, push her buttons and refuse to leave, not to mention the other allegations she's made about full-on domestic violence against her.
Okay.
Finally, Your Honor, so
The
just
judge is
in
done.
conclusion,
Counsel, look at his
we would
face.
emphasize the child is safe with Taylor, the child thrives with Taylor. We would just ask the court to remember that this is a new request for supervision. It is not in the request for the protective order. There has been enormous passage of time between both the 2023 and 2025 incidents. We just don't think it's appropriate at this point to
But not the 2026
commit
incidents.
such an invasion in this parent-child relationship based on such old allegations, and including allegations that have, such as the 2025 allegation that have an explanation.
I have so many questions about the May 2025. I'm going to have to go back and look at timing of the show, because again, at some point, what is happening?
As to my client's conduct. Remember, Your Honor, the resources and network that's currently surrounding and helping this family right now. Lots of help from family, therapists to DCFS. There's been a lot of actions that Mr. Mortenson has made that contradict what he's telling the court today. Most importantly, I think, his decision to give my client custody only 6 months ago, after 8 of the 11 incidents in his exhibits
think that's your best
took
argument,
place.
counsel.
As for the broader allegations in Dakota's protective order, the court will see on the 30th that this case cannot be reduced to a soundbite snippet of footage. We all know that social media has made its mind up about my client years ago, months ago, based on carefully curated information.
So you are making an argument to the media and not to the court? Because to the court, your most persuasive argument is that they agreed to 70-30 custody after the majority of the incidents they are talking about has happened. That is the better legal argument. We have now jumped the shark away from the legal argument into the media of it all. But the strongest legal argument is they were able to agree to 70-30, and that shouldn't change. That's his strongest legal argument. But now we are moving into, but Your Honor, the media has made up their mind. This has literally nothing to do with placement of the child or with custody. Nothing at all. I'm ready for the commissioner to just be like, pause, because the commissioner hasn't made up their mind based on fucking TikTok. The commissioner has more information than TikTok. Okay. Deep breath. Just, okay.
Protective order. The court will see on the 30th that this case cannot be reduced to a soundbite snippet of footage.
The court's not
We
trying
all
to do
know
that.
that social media has made its mind up about my client years ago, months ago, based on carefully curated information to paint her in a bad light. But the court,
I haven't followed it. I haven't seen it.
yep,
Exactly.
good. But the court does not have that luxury.
But counsel, also, don't play in our face. Don't play in our face. We do not have the information the court has. The information that we do have is that after everything that happened, except for what happened in 2026, they still cast her as the Bachelorette. So I don't know if there was all these carefully curated sound bites to make her seem however you're arguing, because she was still cast as the Bachelorette. So counsel, can we all just agree that the two of them need to be nowhere in the same space with one another? Can we do that for a bit? Can we just do that?
The court, unlike social media, actually.
He is answering some of what's going on social media. The commissioner is allowing him to do it. He's going to do it. However, I can imagine that if you are sitting in Taylor's shoes on this, it seems to me that the information that got to TMZ got there from Dakota. So that information has gone to TMZ. Part of Dakota's sealed filings have gone to TMZ. So this is an answer to that. And we have seen that happen in other high-profile cases where the attorneys use court to have a conversation. We have not seen any leaked documents from Taylor's side. We have seen that from Dakota's side. However, that doesn't change my mind that everyone needs to be separate and apart from one another. It does give context to why counsel's doing this. This is going to continue to this.
Curated information to paint her in a bad light. But the court,
I haven't followed it. I haven't seen it.
Yep.
Okay.
Good. But the court does not have that luxury. The court, unlike social media, actually has to get it right. The evidence, we believe, on the 30th, when viewed in its totality, will show who the real abuser is, who the real violent actor has been during the parties' relationship. The days and weeks that have transpired since entry of the temporary protective order have been an actual hell for my client for a variety of reasons. There's a couple of reasons. Sure, yeah, she's been castigated online, essentially re-victimizing her over and over again. Sure, she's had a massive opportunity ripped from her, but that completely pales in comparison to the fact that her parent time with her 2-year-old son has been
the
outright
focus.
suspended.
Well, you think you're giving me closing argument on the
Yep.
on the merit.
Yep, that's exactly what it feels like, Your Honor. That's exactly what it feels like. Just counsel, put this in a press release and put it out in a press release. This is not the point of court. This is not what court is asking to be done. Your client has a prior conviction. So can we focus? Well, not a prior conviction yet because it's a plea in abeyance. But can we focus on the parenting time? Can we just focus on the parenting time? And I think the court's right. It sounds like you're trying to give me a closing argument. Yeah, it does. Now's not the time.
Sure, she's had a massive opportunity ripped from her, but that completely pales in comparison to the fact that her parent time with her 2-year-old son has been outright suspended.
Well, you think
the
you're
better
giving
argument.
me closing argument on the merits of the case. We're just talking about what's going to happen for the next
Sure.
3 weeks. Okay.
But that last point, though, I think is very critical. She's had no parent time whatsoever, and dressing up supervised parent time as something good for her or even good for the child, I don't think makes any sense at all. She's essentially being thrown scraps when it just does not make sense in the total backdrop of this case, Your Honor.
Counsel?
Can I answer any questions for you?
I think I've asked them all.
Thank you.
I'm going to go to the guardian ad litem next, and we'll work our way back to the petitioner.
I appreciate the mindfulness of the commissioner. I do wish he had cut counsel off. There were legal arguments within the PR, but there was definitely PR within that. The legal arguments that I find more persuasive are, one, the majority of the incidents between Taylor and Dakota happened before they came to a custody agreement of 70-30, with Taylor having 70% custody. So what has changed so substantially since then would be my question. And I think some of this can be handled with, well, we'll see. I'm more interested to hear what the guardian ad litem has to say, with someone supervising the exchange of the child and the two parties having no interaction at all. That seems to be the thing that will make the most sense between now and the next hearing. But counsel was not focused at all, and it's just going to spin out other counsel who feels like they also need to respond. Focus.
May I remain seated, Your Honor?
Please.
Okay.
So
Let's
before
get
I
the
Microphone
ad litem
near you.
Yeah, it's right in front of me. Before I get into my argument, I would just note, we did make a grammar request to Draper Police Department.
The guardian ad litem is speaking. If we need to, we can switch at some point to the Zoom hearing the WebEx that has the other side, because it might actually have the tables. But the GRAMA request is a FOIA request, so a public records request. The guardian ad litem is saying we asked, or we made a request, essentially a public records request from Draper.
We had a response on April 1st. That response was a denial based on the records being with the district attorney's office, and the case basically still being open. So the district attorney's office, from what I understand, is screening charges against both parents.
Did you get any inclination?
And that's not at all what Taylor's lawyer said. Well, there is that. Draper Police denied the public records request to the guardian ad litem. The guardian ad litem, who represents the child's interest, not the mother, not the father, just the child. And the file is with the district attorney, who is considering filing charges against both. That is a very different posture than presented by Taylor's attorney. In that situation, whose version of events do I believe? The guardian ad litem. The guardian ad litem, 100%.
And counsel represented that he'd heard.
I'm going to stop jumping on the point of the court and back that up.
Yeah, it's right in front of me. Before I get into my argument, I would just note, we did make a grammar request to Draper Police Department. We had a response on April 1st. That response was a denial based on the records being with the district attorney's office, and the case basically still being open. So the district attorney's office, from what I understand, is screening charges against both parents.
Did you get any inclination, counsel represented that he's heard that they wouldn't be filing against either party?
Well, from what I heard, that was Draper telling him. I think it's the district attorney's office that makes the decision.
Okay.
And as of a week ago, it's
The commissioner has now clocked it. Right. The police department doesn't bring charges. We have forwarded it to the district attorney's office to make a decision. We don't bring charges. However, trying to represent that to the court as charges will not be brought is not the same. It's not the same.
sounded like they were still making a decision.
All right, okay.
That's not
We
the
might know more on the 30th.
That's not the same.
So I think, Your Honor, in looking at everything, the things that I want to focus on, and I know the 2023 incident is old, and frankly, it involved another child. But I think that it's important in assessing the potential danger to my child, to my client. I think the court touched on volatility, and that's what I see when I watch what's been submitted to the court. So going back to the 2023 incident, and I'll be brief with that. Charges came out of that. The district attorney's office.
The 2023 incident, sorry, that was a rude pause for the commissioner, is the one that has a video that was sold to TMZ that is public, that Taylor Frankie Paul is still on her plea in abeyance probation for.
Filed a probable cause statement. This is directly from the probable cause statement. During the argument, respondent threw heavy metal chairs at petitioner, which put holes in the wall. After throwing 2 chairs, told petitioner to stop throwing the chair. Petitioner was told to stop throwing chairs because her child
Taylor
was next to him on the couch. Respondent then threw a metal chair which struck IP in the head.
Yeah. And that's what
you're
is on the
reading from
video.
the probable cause statement.
That was my summary of the probable cause statement.
All right.
But that's what the probable cause statement says. There were a litany of charges that were filed. There was a reckless child abuse.
And that's on the video. So we see where the guardian ad litem is on this. The guardian ad litem's job is to protect the child, not the parents, and to protect the child from the parents.
Charge that was filed. That was ultimately dismissed as a part of a plea agreement.
Okay.
The plea agreement was a plea in abeyance that would take it from a 3rd-degree felony aggravated assault to a Class A misdemeanor.
Sounds like she successfully completed those terms.
She has not
No,
successfully
she's not.
completed yet. So it was a 36-month plea in abeyance. They will come up on that 36-month period, I think in August, if I remember correctly.
That's correct.
So she was required to do AP&P. She completed everything that AP&P wanted her to do quickly. So she's done a domestic violence evaluation. She's completed the treatment from the domestic violence evaluation. She's done a couple of parenting classes. And at least to date, she hasn't had new charges. She also was, I think, required to refrain from alcohol, things of that nature, typical AP&P things. She completed that fairly frequently. And in fact, I think the domestic violence assessment and the parenting classes were even completed before she ended up pleading on the case.
I think there was one I read, a low risk assessment. Is that?
Yeah, I think that they determined that she was low risk.
There was a low risk assessment, and then there have been the continuing incidents, which I imagine is going to be part of his argument now.
So as I look at that, in my mind, she should have the skills to be able to avoid these situations.
That's a fair
And then
argument.
the May incident happened, May of last year. And what I see when I watch that video, and to be fair, I only have the video, and there's a starting point and there's an ending point, and who knows what happened before and who knows what happened after. But Dakota is holding the child, and that's clear in the video, and she's pushing him and telling him to get out of the house. And she's not just pushing him, she's shoving him, and she's shoving him with force. And at one point, it even appears in the video that he trips and almost falls over while he's holding the child. To me, that makes me very nervous about her ability to control herself and her volatility. I don't understand how you have a situation where you throw a chair at someone, knowing that your child's sitting on the couch, the child immediately starts crying, and this is going back to the 2023 incident,
2023.
and you continue and continue and continue, and you don't immediately stop and attend to the child. That makes me very nervous. And then it's the same thing with this incident that happened in May. The pushing and shoving starts, the child starts crying immediately, and that doesn't snap her out of it. There are alternatives that could have been done if he wouldn't leave the house. Could have walked away and picked up a phone and called the police, asked for a trespassing charge. That didn't happen. That would have been the appropriate way to handle it. I think that the respondent in this case has a very...
I understand where his concern is, because the concern from the guardian ad litem is that Taylor is on a plea in abeyance probation, which means if something else happens, that felony goes on her record. That is normally a very strong incentive. And during the course of that program, she has had to complete domestic violence classes, parenting classes, therapy, remain sober. I have a lot of questions about that, but, and the other things. So the guardian ad litem attorney, this is the attorney for the child, the guardian ad litem attorney is saying, look, she has been through the program that we wanted her to do. She received a low risk assessment. She received the tools that we thought would help. And yet we are back here with the child and Dakota. And so the guardian ad litem's concern is even with tools and a very large incentive, not catching a felony on your record, there are still incidents that are concerning. And that is where the guardian ad litem is coming from. And I understand that. A number of you have asked about the guardian ad litem. The guardian ad litem is also an attorney. Just their client is the child. So continuing on.
Difficult time with self-control, and I think that it puts my client...
I'm going to just back that up. So the guardian ad litem is going to ask for supervision if the child is around Taylor.
And that doesn't snap her out of it. There are alternatives that could have been done if he wouldn't leave the house. Could have walked away and picked up a phone and called the police, asked for a trespassing charge. That didn't happen. That would have been the appropriate way to handle it. I think that the respondent in this case has a very difficult time with self-control, and I think that it puts my client at risk, and has historically put him at risk.
What about the argument made by Mr. Swinyard that but for the parties interacting with one another, that's where the anger is directed at him, not at the child, even though it may be inappropriate conduct, that if they're not in the same place at the same time, that the triggering elements are not there for her to lash out.
I agree that the anger is directed at him. I don't think that the anger has been directed at the child. That's actually demonstrated, I think, in the child abuse charge that was originally filed. They filed it as a reckless charge, not an intentional charge.
Right.
So I think the anger is directed at him, but I'm not convinced that there won't be anger directed at other people that can result in the children being harmed. That's my concern, is just a lack of total self-control, even having been through all of the treatment for domestic violence and things of that nature. And that really concerns me. So I am asking for supervised visits today.
And that's what's
I think the
probably
court
gonna
can order
happen.
that if the court finds that there's potential harm to the child.
That's what's going to happen.
I think based on what's happened historically, the court can find that. We've discussed doing third-party supervision. That was one of the first requests I made when people reached out a couple of weeks ago, is send me people who I could consider for third parties. I hadn't made a decision at that point or even looked at the evidence, but if it got to that, I wanted to be able to vet people. I heard back from Petitioner, who was suggesting an agency. I heard back from Respondent last night with one person, and then they provided 3 more this morning, so I haven't looked at them. As the court knows, the statute prefers an agency for reasons about neutrality and, being trained in child abuse reporting and things of that nature.
Right. The third-party supervisor is not going to be one of her family members, one of his family members, a friend. It is going to be someone who has more training than that and has eyes out to protect the child. All right, let's continue on.
I think that it would be appropriate to do an agency.
How old is the
That makes
child in this
sense.
case?
He's
again?
2.
2, so you couldn't really interview this child.
Correct.
All right. Anything further?
No.
All right, let's go back to you, Mr. Swinyer, to any rebuttal on what the guardian ad litem has just indicated.
So now they are going back to Taylor's attorney. It makes sense to me that if the guardian ad litem is asking for there to be supervision, that's what the court's going to do.
I would just emphasize what I've already said, that her anger is very clearly, unambiguously directed at Dakota, has nothing to do with the children. So at this point, we do think it is appropriate and certainly consistent with what these folks have historically practiced to suspend and essentially strike those paragraphs 15 through 17 from the temporary protective order and restore that custody arrangement that he agreed to.
Yeah, I don't think that's going to happen.
Only 6 months ago.
Okay, all right. And let's go back to you, Ms. Diaz.
The thing that's difficult is that she can't control Dakota's actions. She can only control hers. And when the guardian ad litem is like, right, and we have huge concerns about that, they're going to grant supervision.
Rebuttal.
Yes, Your Honor.
And this is Dakota's attorney?
The first thing I'll say is that, a mutual protective order can't be entered under the rule. And in this case, it wasn't filed when it could have been filed previously to have that argued today. So that isn't what is being argued today. And what we are looking at today are parent time orders moving forward. And I think that a request for supervised parent time is not prejudicial under the statute. In fact, it's something we see often in cases of domestic violence. And some of what was brought up by opposing counsel here, I think, can really be understood in the larger context of what a cycle of abuse looks like. What two people who are maybe sometimes cohabitating, sometimes not, going through a cycle of making up, fighting, breaking up, going through a honeymoon phase, having this incident, having an incident happen, and the entire thing start all over again is what we see here.
I know the cycles of domestic violence.
Time and time again.
This is a commissioner in family court, ma'am. This is it's all, and I'm sure, which is why the commissioner is just like, can we just stop? Because they're just going to go with the GAL. But I understand that counsel wants to make a record after opposing counsel made a record throwing her client under the bus. I understand that.
Again, what we see is that the respondent is the aggressor here, and that she not only is putting my client at risk, but the child at risk as well. Okay. And let's just turn to a couple of things that were brought up. So, looking at the February incident, my client was invited that day. In fact, one of the ways that we'll see as this, plays out, coercive control happening, is that he's often invited back, and his child is often used as a pawn to start fights, as a pawn to create incidents. My client is doing everything he can.
I understand talking with your hands, but with how zoomed in the camera is, the talking with the whole body is tough for me to follow. Also, both sides are going to want to make their record. However, I think the court has tried to focus them. You made your record first. Can we just focus back on the guardian ad litem? The guardian ad litem said, and just leave it there.
Okay. At this point, to try and protect his son. That's what this case is about. That's why we're here today. So the orders that are made here today for the minor child are extremely important. They're extremely important because this is the case. This is the case for the petitioner, is being able to keep his son safe. Leaving in abusive circumstances is not easy. It's not easy to get away from. Many people attempt many times and fail many times. But what he's doing here today is trying to protect his son. And her violence and her behavior, it has escalated since the initial 2023 incident.
Can we
Now,
talk about
they
the
did reach a
custody?
stipulation in their custody case.
Yes, that,
and,
good.
That was
that.
after the May incident.
and that was
Yes.
after the May incident. And that's really
That's what the court wants you to talk about. That's what I agree with the court. Can we talk about that?
common, I think, in cases where people are trying to make up, trying to play nice with each other, have been getting coerced by the other party for some amount of time, but also
Well, it's a different context. I mean, they were in a formal mediation setting with attorneys, all right? It's
Right,
a little
let's
bit
not-
different than making promises, I think, after an explosive event, but.
But
okay.
since then, there have been
Right.
more incidents, Your Honor, and there has been the February incident. And
Right.
if we want to look at how the parties behaved after the fact, go ahead and look at the petitioner's Exhibit 10, which shows that after the February 23rd and 24th incident, the respondent made 151 phone call attempts to him.
I'd object as to foundation. The date of those calls has not been demonstrated and cannot be demonstrated from Exhibit 10.
I mean, I think there's a point there as to what the relevance is about that.
Well, Your Honor,
And the veracity. I really just wish everybody would stay focused. Because the court pushed back on Dakota being coerced into reaching the custody agreement. And he's like, counsel, they were in mediation with lawyers, formal mediation. They were not on the phone trying to make these agreements. And they were all represented. So there was thoughtful conversation. Focusing on that is a lot. However, when we get to the phone calls, there is a debate about whether or not those phone calls are reflected on the carrier records or just on the phone screen. And there has been some conversation about whether or not those were calls actually from Taylor or not, but they don't have the carrier phone calls. So what's screenshotted on a phone is what's screenshotted on a phone, which is why counsel's objecting as to the authenticity and foundation of that. And the court's like, yeah, and relevancy. Yeah, and relevancy.
The date of those calls has not been demonstrated and cannot be demonstrated from Exhibit 10.
I mean, I think there's a point there as to what the relevance is about that.
well, Your Honor, this would be for the purposes of rebuttal. What opposing counsel said was that after that incident happened, that his client was trying to get away from my client and not be around them, and that isn't true based on their call logs.
I mean, I think it might be relevant in the context of whether a protective order eventually issues, but I'm not finding that it's relevant for purposes of parent time for the
Your
next
Honor,
3 weeks.
I guess what
Counsel?
I'll say is there's some credibility problems happening here on the part of the respondent as well, and what's being reported by the respondent as well.
There may very well be. Certainly, it's not the first time that we've heard disparate factual representations in the context of domestic violence.
Of
Right.
course. So,
From both.
and as far as I know,
Attorneys.
there was a discussion about police reports. As far as I'm aware, Your Honor, is,
Counsel, were you not in the room? There is we just had that discussion. We just had the discussion about the police reports.
I don't know that those are going to be released until the police department determines that their investigation is finished and that file has been closed. So we'll see what happens moving forward with that. But there are more incidents that show that more recently violence has been directed towards the minor. I'll draw your attention to Exhibit 9, in which the parties were in an argument, and it's mostly an audio.
The
but
GAL
the
didn't
respondent
say that, though.
kicks down the minor child's door. Well, when the minor child was in there, kicked the door down when the minor child was in there sleeping. And so I think that
Why didn't
supervision.
honestly, chat, let me know if you're with me on this. I just want to hear from the guardian ad litem at this point, and not with both counsels. They're both gonna just do this. I would like to hear from the guardian ad litem. Just go with that. Just that. But the guardian ad litem didn't bring it up.
Is incredibly appropriate in this case. Although there are voluntary cases with DCFS open, those cases are voluntary. There isn't any judge that can enforce that if either of the parties decide to stop complying with those services or decide that they don't.
You're
want to
talking
move
about
forward.
voluntary services. We're not talking about, or are we, about an open investigation into allegations of child abuse.
So, Your Honor, the division has not supported child abuse. They've supported domestic violence-related child abuse against the respondent, and they've supported failure to protect against the petitioner.
Okay.
And they're working they call it a voluntary case. It's essentially giving them services.
Okay.
So the guardian ad litem just answered that question. There is not a DCFS investigation into taking the child away from an individual, probably because they don't need to. This is already going through process with the courts. The guardian ad litem is like, services are being provided. Right. That was the GAL that spoke up and kind of corrected the record.
About an open investigation into allegations of child abuse.
So, Your Honor, the division has not supported child abuse. They've supported domestic violence-related child abuse against the respondent, and they've supported failure to protect against the petitioner.
Okay.
And they're working they call it a voluntary case. It's essentially giving them services.
Okay.
Okay.
So
What does that mean? DCFS has issues with both respondent and petitioner. Respondent, Taylor Frankie Paul. Petitioner, Dakota Mortenson. DCFS has issues with both of them. And so services are being provided. And that is why there is a guardian ad litem again in the middle of this. And that is why there should be guardian ad litems in the middle of this. Hard job, very needed job. I also appreciate the guardian ad litem correcting the record and being like, look, DCFS has questions for everybody.
Actually, a case would have to be filed for those services to be able to be court enforced. And I will say that since that stipulation on the custody case was reached, the parties were following it somewhat, but the respondent was out of town for a lot of that. She left to go to work. She was out of town for like several months. So my client has been a primary caretaker.
I mean, I don't know if she was out of town for several months. However, the zoomed out perspective makes the motion a lot less difficult. But yes, she was out of town to film The Bachelorette. I don't think it was several months, but it was over a month, I believe.
For this child. He is completely capable and able of providing this child with the care they need.
Again, we're just talking about her parent time between now and the 30th of April.
The court's like, focus.
So we're in support. We will agree with everything that the guardian ad litem has argued, Your Honor.
All right.
There we go. That's it. That's what the court wanted to know. Do you agree with the GAL? Yes? Great. That was all that was needed. And Exhibit Illy said that's work. It's not fair, though. It is fair for comment because the comment is that he's capable of having custody of the child in response to Taylor Frankie Paul's attorney arguing that he is not capable of taking care of the child in the way that he's been taking care of the child. Taylor's attorney started with the argument that, I hear a George, which means there's going to be a Travis. But Taylor's attorney started with that argument that he was not able to take care of the child. Hey, T. Hey, George. Good to see you. We're talking about custody.
Law.
Yep.
Talking about law.
Yep.
Law.
George, did you notice George immediately stops meowing when picked up by Travis? Hi.
Oh.
He's like, okay, I'm going to go watch the birds.
Yeah.
How are you?
Doing good.
Good?
Yeah.
Awesome. We're going to finish up this hearing and then we'll be done. Are you going to take him with you? Or is he going to stay here with the birds?
He's going to do whatever he wants.
All right. Thanks, T. George is immediately out, immediately following Travis. So Taylor's attorney brought it up that Dakota didn't have the family support and the support in the community and was heavily relying on others to take care of the child. And that's why his attorney brought up the responding point saying, no, he has managed this before when she was out of town for work. So that's part of why it came up.
My recommendations, I'll close argument at this time. And
The court's like, everyone done. Let's go. Everyone done. Okay.
We're in support. We will agree with everything that the guardian ad litem has argued, Your Honor.
all right, I'll go ahead and make my recommendations. I'll close argument at this time. And I just
Yeah,
want to
supervision, I
reemphasize
imagine.
that once again, the decision that I'm making today is very limited
It's a
in duration.
temporary-
We're talking about a parent time arrangement that'll be in effect for a little over 3 weeks. Well, yeah, a little over 3 weeks.
And we'll be back on
right?
April 30th,
And
it
then
sounds
we're
like.
going to have a full hearing on the merits of what may be competing petitions.
How long until we regret everything? Because that is going to be at least, I imagine that's going to be a full day of a hearing with these attorneys. Emily, you said we hadn't covered civil restraining orders. We had not covered family law. We hadn't. No, we hadn't. Okay. And now here we are.
For a protective order, there may be a parent time order that comes out of that as well.
Probably.
So we may be doing some of this over again. And we may
Probably.
know more information by then too. We might have a police report at that point. We might know whether or not, for certain, whether there's going to be criminal charges filed against one or both of the parties.
Right.
And so, and I want to emphasize too that I'm not making any determination today, one way or the other, about whether the respondent in this case may also be a victim of an abusive partner as well. I mean, that's part of the allegations that are being made. There's mutual allegations at this point. The prior allegations have played themselves out in the criminal court. I don't know at this juncture, hearing what the guardian ad litem indicated about there's not yet been a dismissal of that prior criminal
Correct.
matter. I don't know what may come of that. It may be dependent.
Well, if criminal charges are filed, it's going to violate her plea in abeyance. Even if criminal charges are not filed, it violates her plea in abeyance and could change her situation dramatically, which is why the guardian ad litem was so concerned about it.
Upon what law enforcement intends to do with the current incident, the February incident.
Yep, that's going to matter
I do
a
give
lot.
A lot of weight to the input of the guardian ad litem as well. Guardian ad litem is someone who's trained. Well, someone who's trained in forensic interviews of children, but the child is really too young in this case to provide any valuable information. But the guardian ad litem also whose only interest is in advocating for the best interest of the child, not getting necessarily a spin from what would be an inherently biased party, meaning mother or father. Not to say that they're not each, from their own perspectives, being truthful, but simply that there is an inherent bias there as well.
Well, yeah.
And I do share some of I have concerns going both ways, quite frankly. I do have some concerns on the
Fair.
one hand that perhaps there has been some, as I indicated, maybe pushing of buttons to get a reaction. It's certainly been, no one disputes, a volatile relationship. As I looked at some of the evidence that was submitted, it seemed like a lot of this was going on when he was coming to her place of residence.
Right.
That could have an impact. But also, regardless, the reactions that, even if he was trying to provoke a response, the reactions that actually occurred, they're very troubling. I mean, the one from 2023, I'm not giving as much weight to because it's removed in time, but it's still indicative of volatile,
big a response.
volatile reactions.
Right.
And the hard part for the court is when it happens in the presence. I mean, it's hard in any event, but especially when there's children present during the incident. That's the most difficult part of
And
all.
concerning.
The May
Right.
2025 incident it occurred while the child was in the arms of the petitioner. And there just doesn't seem to have been any thought put into what the effect that this might have upon the child. And that weighs heavily with the court. And so for these reasons, I'm going to recommend, again, this is very limited duration, we'll have more information, but I'm going to recommend supervised parent time for the next 3 weeks and 2 days until we come back on the 30th. And we'll have more discussion about this. And I would allow that to be for up to 6 hours per week. We can break it up into 2 3-hour periods, 3 2-hour periods, whatever frequency works for her at the availability of a supervisor. The statute does talk about now, it's sort of flipped on its head, the old order of preference would be to relatives, friends that might be available,
And that's
moving
not
more
gonna
towards
be helpful.
a paid supervision
That's
service.
going to be much more helpful.
As of
Yep,
May
that-
of 2025,
yep, that-
with Ohm's law, that's changed. And now the preference is to a professional individual. Well, let's start, it would be a professional individual or private agency trained in child abuse reporting laws, the developmental needs of a child, and the dynamics of domestic violence, child abuse, and sexual abuse, and substance abuse. If that's not available or practicable under the circumstances, then we can turn to an individual that has these similar types of training. And then if that's not available or practicable,
That makes sense.
then we're looking at friends, family, relatives, that sort of thing. I don't know if there was an agreement between the parties as to a mutually agreed upon third
I
person
don't know
that
if there
could
was.
do this or not.
There's not an agreement.
Historically, there's been an agreement. Historically, they've participated with 4 different friends and family members in providing
That's
care
not what
and
he
supervision
said.
of the children.
That's
Was there a
Taylor's lawyer.
proposal that was set forth by you or your client to the guardian ad litem as to who ought to be?
Yes, we're proposing that the parties be able to use those 4 individuals as part of the,
That's
if there is to be
that's not what petitioner asked for, though, respondent.
supervised parent time, that the court uses those for.
Are these people that are aligned with her?
Well, it's
Well-
safe to deduce that. One is our client's mom, client's sister, a cousin of my client, and then a shared nanny that both parties have used. But again, even though on paper they appear to be aligned, Dakota has actively taken advantage of these services, or taken advantage of their time historically.
I think in some respects too, and I don't know if you've considered that using a supervision service might actually protect her
Protects-
from false allegations
Correct.
as well. I think the concern that comes up with
I like this commissioner. I think he could have cut the lawyers off earlier, but commissioner's seen some shit. Commissioner is like, it's 3 weeks, everybody. It's 6 hours a week. Let's just all take a breath and go with a professional. And I appreciate that the commissioner's like, and it benefits your client too. So do not just discount it because the other side is proposing it. Thank you. Thank you very much.
I don't know if you've considered that using a supervision service might actually protect her from false allegations as well. I think the concern that comes up with friends and family is that on the one hand, let's say if there's someone that's selected by the one to be supervised, the other parent may feel like they just won't do their job.
Right.
On the other hand, if it's someone selected by him, she may feel they're hostile towards her and
Right.
it won't be conducive to effective parent time. So at least you're having a neutral observer who's documented that might give us some indication about how's the child responding when she sees mom after a while for a long time.
Right.
Sure.
Might be better.
It might actually be beneficial for everybody.
My client's very interested if she's being given a very small amount of parent time, which The court has said 6 hours. Mr. McDonald has separately told us he'd be looking at more like 8 hours. So I think that would be worth a separate discussion.
I'm okay with expanding that, yeah.
She's very concerned about the quality of parent time and believes that the quality of parent time will be better with someone who the child is familiar with, someone who my client is comfortable with. And, the court has already indicated some reluctance or some openness. I believe that this certainly would at best be an edge case for supervision. So if there is a case that the court can drift away from the statutory preference and allow family to step in, I think this would be it.
Have you vetted anyone?
So, Your Honor, I have not fully vetted everyone. So they gave me the 4 names. The first 2 names, the one thing that I did.
And that's the other problem for the guardian ad litem. We are talking about between today and April 30th. So if the guardian ad litem has to vet everybody, it's going to take what? A week or more? So services that the GAO has worked with before is not going to have to be vetted the same way. Okay.
Because I just had time to do it because I received the names this morning, is I called the DCFS caseworker and asked her for her opinion. She was unfamiliar with the second 2 names. The first 2 names she was familiar with. Her concern would be that she believes that client is very aligned against Petitioner, and that would be my concern too. But what I would be willing to do is vet these folks for when we come back on the 30th and maybe have a different recommendation.
Do you have instructions for proposed supervisors as to what their obligations would be?
Our office has instructions that we would discuss and confirm that they would be willing to do it.
I might be willing to go there vetted by the guardian ad litem, and we get a statement from the proposed supervisor that they'd be willing to submit themselves to the jurisdiction of the court so they can be held accountable.
Zero problem with that. That's something
boy.
we can work on today with those folks.
Okay.
However, that's
Increase it to 8.
that's not going to happen until the 30th, which means what are you going to do in between?
8 hours. Certainly it's going to be subject to availability. I'm not eliminating necessarily paid supervision. I don't think this is necessarily an intentional child abuse case either. I do think that there's potentially incidental child abuse that has occurred, domestic violence in the presence of a child. I still have some concerns, but certainly if they're being vetted and approved by the guardian, if they're submitting themselves to the jurisdiction of the court, it's going to take some interaction between counsel to try to work out a schedule between now and when we get back. Okay?
Great. Yeah, we can work on that immediately, Your Honor.
We're talking a 2-year-old, maybe frequent, shorter sessions may be better than one long session
Sure.
or 2. Okay. All right.
So as I understand it, the court, pending the guardian ad litem's vetting of the options, the court would allow supervision to take place by these folks in addition to having the option of a professional supervisor.
Right, and I'll just indicate too, pursuant to statute, that this is only designed to be in effect for as long as necessary, and if it
And this is going to
goes
change.
beyond the next hearing, we'll probably have periodic reviews as well. All right, as required by statute.
And Your Honor, I know that my
I don't know that it
client
will.
has some concerns about
That's Dakota's
some
lawyer.
of the respondent's family members being able to hold boundaries and keep her to account. So would it be a requirement that that document, submitting them to the jurisdiction of the court, would that have to be filed before those things could take place?
I want that to happen, yes.
Okay.
Yeah.
No problem.
Okay. All right, anything else from either party, guardian ad litem?
No?
That I'm aware of.
Okay, we'll issue then an amended temporary protective order with the ruling as indicated today. We're working on that now. It may take a few minutes to get that drafted, and I'm going to want to review that before it's issued. If you
Do you
want,
want
we can
to-
print off a draft and have the parties look it over, and then if there's an issue, I can come back, and otherwise, as long as everybody approves of it, the attorneys and the guardian ad litem, we can go ahead and get that issued. And
Okay.
if need be, I can come back if there's a need for clarification.
Your Honor, do you have any scheduling concerns now with the latest, with my client's request for
This is
protective order
Taylor's
having been filed? Do you have any
attorney.
scheduling concerns for the 30th? We're set to go at 3:30 on the
It's the
30th.
same incident, right?
Same incident, I guess, just more stuff.
There's a lot of overlap that I'll be hearing. In other words, I don't think it's going to take much, if any, more time than if I'm hearing only one
Okay.
protective order action versus another.
All right.
My main concern is being able.
Y'all think you're going to do that in like an hour and a half? Yeah, no. Yeah, after watching today, I have concerns that y'all aren't going to have enough time if the 30th doesn't start till 3:30.
In other words, I don't think it's going to take much, if any, more time than if
You're going to
I'm
have to cut
hearing
those
only
lawyers off,
one
Your Honor.
protective order action versus another.
All right.
My main concern is being able to have my staff go home at 5.
Ding, ding, ding.
But if it needs more time, we'll
Ding, ding,
if you
ding.
think it's going to need more time than an hour and a half, let
I
me
do.
know, and we can perhaps do a scheduling conference to tweak the time, and
You're going to need more
so we can give you
time.
as much time as this case needs and deserves.
You're going to need more time, Your
Thank
Honor.
you. We'll reach out to your clerk then, once council's had a chance to look at the documents and
Okay.
evaluate it.
Okay, all right.
So that
No,
might
I'll be
move.
gone between the 16th and the 23rd.
Good for you, Your Honor.
All right, court will be in recess until 1:30. Let me know if I need to come back, okay?
Mayor, remain seated, court is now in recess.
Extreme zoom out. All right. And we are done. That is the end of this hearing. The court is on recess until after lunch when they will resume
I just want to review
I've forwarded it.
all of their other calendar matters. I'm just going to see what happens in open court. It's a small courtroom. A lot of you have asked about this screen. We have seen them in other courts where they just pop up out of the furniture essentially, and then pop back down. And that is where the Zoom or WebEx participants are in court. We'll see if anything else happens just with the mics open in court, but the commissioner is leaving the bench, and then we will answer questions. All right, Commissioner M, thank you so much. So you'll see the other parties like logging out.
Maybe I was driving, because I just want to review the
I've forwarded it probably at 10 o'clock.
We'll get phone numbers.
Yeah.
Okay.
Could you
Give us
just
a
send me
minute.
the name, the list of names?
List names, yep, we'll definitely do that now.
Thank you.
Print it off as a draft at the lawyer's office.
This is a small court. Some of you were asking about the typing in court. I will just note, the lawyers' microphones are all right down here on their desks next to where they are typing. So if the typing was on those laptops, the court wouldn't hear it. Also, the judicial clerks are going to be working while the court is on the record, oftentimes typing up the order as the court is going. So sometimes you'll pick them up too, but the microphones are right there where the computers are, and attorneys are often noting down what the court is ruling. Oh, well, we'll just keep it open. No, we won't. Let me scan and see if there was anything else. Anything else? I don't think that there is based on the end of feed. All right. Let's summarize what happened and then answer some questions, because that's where we're at. All right. Where are we at? Well, let's back up a little bit with what was being argued. So when Dakota Mortenson filed the request for a temporary restraining order, he filed that back on March 19th, 2026, relating to 2 incidents in February, though Taylor Frankie Paul's attorney has argued that that was like overnight. So it was really one continuing incident. It just went over the midnight hour into the next day. So it wasn't 2 different instances. It was continuing. That was part of their argument. He filed that March 19th, same day that TMZ had some of the sealed filings from his filings, some had the video from the 2023 incident, and more. As a part of that March 19th, 2026 filing, He requested temporary full custody. That changes the custody agreement that Taylor and Dakota had reached in the custody case. Sometimes the commissioner is calling it the domestic case, but in the custody case, they had come to a settlement in their custody arrangement prior to this. So the temporary protective order changed the custody arrangement to give Dakota full custody. The reason they were in court today was to navigate that custody arrangement because it changed the 70-30 custody that they had where Taylor Frankie Paul had 70% custody of their child. Dakota had 30%. And we saw at one point Dakota's attorney pointing out that while Taylor was away for work, I'm presuming filming The Bachelorette, she was gone for, she said, months, and he had custody of the child at that time and was more, she said, than capable of taking care of 100% custody. We also heard from the guardian ad litem, who represents the best interest of the child, which I think is going to be the grounded point in this case as we move forward. The argument from Dakota's attorneys were, we think it should stay this way. We think it should stay with Dakota having 100% custody. However, we are willing to have Taylor have time with her son if it's supervised. Taylor's attorneys were saying, we want to go back to the status quo of the custody agreement. This isn't an issue that Taylor is going to harm the child. The issue is when Taylor and Dakota are together, is what Taylor's attorney was arguing. That when Taylor and Dakota are together, that is the problem. If Taylor and Dakota are not together, then there is not a problem. The problem that the guardian ad litem and the commissioner highlighted is that when Taylor and Dakota are together and the child is present, it does not stop Taylor in escalation or in reaction in a way that could be and has been in the past harmful for the child, which is something that was concerning to the guardian ad litem and to the court, that the response to Dakota when the child is present is not mitigated by the fact that the child is present, and that is the court's concern. And so ultimately, the court went with the petitioner's request, that's Dakota's request, that time with Taylor and their son be supervised until the next hearing, which at this point is set for April 30th. However, I suspect that that date might shift a little bit because the attorneys are now indicating, well, Taylor's attorney is now indicating that 3:30 might not be enough time. That's a 90-minute window. And the court's like, look, I want to make sure that my staff is done at 5. After what we saw today, I do not think that they will be done hearing the merits of now 2 temporary protective orders. And if they will try to navigate the merits of that, trying to figure out a little bit more of what happened, not just custody. Today, the attorneys went far afield. More so the attorney for Taylor Frankie Paul, but went far afield to try to litigate the facts underlying the petition, not just talking about who or what the custody arrangement should be for the child. Apologies. So in trying to navigate that, the court tried to rein the attorneys in, but seeing how much argument there was, I do think they're going to need more than 90 minutes. And the reason I say 2 temporary protective orders is because as of this morning, Taylor Frankie Paul had filed a request for temporary protective order. And I do use protective order, restraining order synonymously. However, in Utah, they are different. So when I use them synonymously, I apologize. I default to California language, but they are civil protective orders. They are not part of any criminal case. So when they were arguing that, Taylor's attorney said, hey, we've also filed a restraining order against Dakota. So we are now asking for mutual restraining orders, it seems. Most interesting to me in all of this is we saw both attorneys arguing, the other side, more so from Taylor's attorney, I think. But then we saw the guardian ad litem kind of putting a check on Taylor's attorney saying, hey, we have also done a public records request, a GRAMA request, as it is called in Utah, but we've also done a records request from Draper PD. We were denied. Draper PD indicated that the file is with the district attorney's office. They are determining or considering whether there will be charges for both parties, Dakota and Taylor, and yes, both can be charged. Just broadly and generally, we don't know the facts of those incidents or the overnight incident in February. So we don't know the facts of that. But yes, there can be instances where both parties are charged for domestic violence against each other in the same course of conduct. So the guardian ad litem indicated that DCFS has concerns about Taylor, Frankie, Paul going after Dakota when the child is present, and Dakota not removing himself and the child from the situation is how I read between the lines when the guardian ad litem was saying the concern about the petitioner is the failure to protect. The concern for the respondent, Taylor, is the domestic violence in the presence of a child, which had been one of the charges that was dropped in her criminal case. So DCFS and the guardian ad litem have concerns about both parties and have indicated that there may be criminal charges for both parties. The attorney guardian ad litem indicated that one of his big concerns with Taylor, Frankie, Paul is that there is still an open criminal case that she has a plea in abeyance on, that these subsequent instances should or could, the guardian ad litem didn't say should, I said should, that could violate her probation in that plea in abeyance, which means that that would then be converted to a felony charge. It would not be reduced and essentially come off of her record. But the bigger concern is that she has gone through the domestic violence programs because of that plea and successfully completed it and had a low risk rating when she completed that. And yet there are quite a lot of subsequent incidents. I was now conflating instances and incidents. There are now quite a lot of incidents between the two. And of course, the guardian ad litem is concerned for that. Their concern is the child. So the guardian ad litem is kind of the grounded voice in the courtroom along with the commissioner because their interest is the child. And look, I did not work in family law. There are reasons I did not work in family law. If this is your first time observing a family law court, A, I'm very happy for you. B, that is not the off the rails of family law. That is a toe tipped into the water of family law. Family law is difficult. Custody is difficult. My interactions with family law all came in the way of juvenile prosecutions, where half the time I was looking at the juvenile and I was like, there is nothing I can do about the fact that your parents suck. I really wish there was more that I could do about the fact that your parents suck. I can't prosecute your parents. You are in juvenile court, and juvenile court ended up also trying to work with services to try to protect the kids that needed protection. And it was incredibly frustrating looking at kids being like, dude, I don't know, man. I don't know. This situation's not good for you, but the other situations aren't good either. There's not a lot of good answers here, which is difficult. Here, I think the best answer is that Taylor and Dakota stay away from each other for a substantial amount of time, and that they navigate co-parenting with support. Because that is necessary. It's necessary. The support is clearly necessary. So when we go back to court on the 30th, we're going to see, we're going to see. But what might happen before there or before then? Well, one or both of them could be charged and or not charged, which will inform what happens next in court. Taylor could still face probation consequences in the criminal case, and the child custody hopefully will go smoothly between now and then. And then they will be back on the protective orders. The court noted some interesting things that went by kind of quick. One, the court noted that they are aware and attuned to a party filing to gain an advantage in a custody case. This commissioner is in charge of the custody case. This commissioner is going to be in charge of both protective orders and the custody case. The commissioner also noted that they were not making any findings of fault. This hearing was solely to decide what is in the best interest of the child until the next hearing. And so the court has questions for everybody, but I imagine that the court, after being represented or having represented to them by Taylor's attorney, that Draper indicated no charges and the guardian ad litem's like, that's not accurate. That's a problem. That is an error for counsel, because the commissioner's face immediately went, what did you say? Oh, good. As we have mascara on the top of my eye. That's good. We've raised our eyebrows enough to A, mess them up, and B, have makeup on them. But when the commissioner is looking at you going, you said no charges, and the guardian ad litem, whose word we are taking, the guardian ad litem said that the police afforded to the district attorney's office. Those two things are not the same. Those two things are not the same. It burns your credibility with the court. And you can understand why. It burns your credibility with the court. It's so frustrating. Like, what are we doing? Little Queen asked, has anyone watched the program? Could I get a better understanding of what's going on? It's toxic as fuck. It is incredibly toxic, and that's what is going on. It is incredibly toxic, and that's what is going on. And if you watch it after seeing this, you will see the pattern between Dakota and Taylor cycle and cycle and cycle and cycle and cycle repeatedly. So I don't know if it will give more clarity. It might just bring more frustration. So I am frustrated to see counsel, stumping for facts not in evidence when they are not accurate. That really, really, really frustrates me. Because it's just as easy to say it's been forwarded to the DAs and no decision has been made. That's not what was said, though. And that frustrates me pretty deeply. Each party is going to have clearly very different perspectives on what has happened between the two of them. It is the job of the lawyers to ground those arguments and present the strongest argument for their clients, and to not get caught up in their client's whirlwind, which is hard. But when attorneys get caught in their client's own, tornado of emotions, it does not go well. Emily, you opted out of family court. Yeah, I did. Yeah, it's an incredibly difficult job to not get caught up in the tornado of everyone else's emotions, because you're an advocate for your client. You are there for your client. You are there to protect them from the other side. However, sometimes that also involves protecting them from themselves. And it is a balance. And it is not a balance everyone is good at striking. And it is not a balance that all attorneys take to heart, because there are plenty of attorneys who view their job as, it's my job to win at all cost. I think in family law, when that happens, it can be difficult, which is why I'm glad there's a guardian ad litem in court in all of this, because the guardian ad litem is also there to keep a check on all of it, which honestly, I'm really glad for. I'm really glad for. Really, really glad for. So, for those of you that have not ventured into family court, it's frustrating and there's no good answers. It's frustrating and there's no good answers. In this case, the good answer for now and for a while, is for them to have no contact with each other. From my perspective, I don't know everything. I don't know these individuals. I have just watched it play out in the media. in, an edited TV show, on social media, and now in court. And my perspective on all of that is that they need to not have contact with each other for a good long while, because it's going to take a good long while before it can be healthy contact based on everything we've seen. And they need a third party to navigate custody for a while. And then we'll go from there. That's what I see from this side, because there is a lot of toxic behavior, just a lot of toxic behavior. And until they are completely away from one another, I don't see how that stops. And that probably means that there will not be any more filming of Secret Lives of Mormon Wives. Also, it is always hard to deal with cases that play out in media, in social media, and in court, especially when there is a lot of nuance. And that does not excuse ever anyone being violent. But there is a lot of conversation in family law cases about everything that's going on, and that's what the court's there to decide. My perspective is both parties need to not be in any proximity to one another. And that needs to be for an extended period of time. And that's what the court is going to have to navigate through both of these cases and through the custody case. That's really hard when all their money is tied up with each other and their jobs are tied up with each other. But I hope that they are able to separate, they are able to get away from each other, and they are able to both love their kid without destroying each other or themselves. And I think that means that all of this needs to not be on reality TV, but now it's going to be in court. So it's going to be tough. One Nippy Hippie said, isn't Dakota on a new show though? Apparently they're editing him out of Vanderpump Villa, but I think he is on another dating reality show. But also, I would imagine if he gets charged, and yes, both of them can be charged, I imagine if he gets charged, that would have to change. We're just going to have to see. And then there's going to have to be more conversations about, where this all goes. I mean, with reality TV that is it used to just be you know what, chat, here's where I'm at. And then we're going to get to questions. Can we just bring back MTV Cribs? Can we bring back Cribs and Unplugged? Can we bring back other forms of non-scripted television? I have found myself watching a lot more competition shows because some of the relational reality is really a struggle. Can we just bring back Cribs? I want to see Cribs, Pimp My Ride. I'm here for that. Competition shows, here for that. Fucking love Traders. But I think the rest of it, we just need a minute. We just need a minute, because we're getting to a point, or I worry we are getting to a point, where the detriment to the participants is unavoidable and is also detriment to the audience and the participants. So we'll see. I miss fun reality. I'm not saying it was ever not toxic, but it didn't used to be as heavy. And I miss, Cribs and Pimp My Ride and lip sync battle. You know? There's other stuff, right? But with that, we'll have to just keep talking about it because it's tough. It is. It's tough. It's tough. And it's tough to watch. Absolutely miss Queer Eye. Absolutely do. So we'll see. We'll see. But it's, it's heavy. And family court's going to be heavy, which is why I put all of the warnings that I could before today, because it's a big warning. Let's get to some of your questions, and then we'll be there. And then we'll be done for the day. I'll go see T. I hope you guys had a good weekend. I have new flowers back there. I'm gonna have to send you a picture, Law Nerds. I'm gonna have to send you a picture. Yeah, I'm gonna have to post a photo of them because they are Lego that I got for Easter, and I love them. I love them. I love them. I love them so much. So, Law Nerds, let's have a chat. Let's answer some questions. Be kind to yourselves. It's heavy stuff to watch, and it's hard, and it's frustrating. And at the end of the day, I don't want this for any of the kids involved in this. And because there are kids involved, it's not just you two stay away from each other and get over yourselves. It becomes heavier than that because kids are involved, and it impacts the way that they grow up. And that's heavy. All right, let's get to questions. Are you ready? I'm ready. We're ready? Let's chat. I know. I love the Lego flowers. I love how many of you also love the Lego flowers. I love it. I love it so much. All right. Celestial said the message in the app was showing gray text on the dark background. I have no idea, but Celestial, you are not the only one who had issues with the app today. Glad we're not in trial. You are not the only one. I've made a note to Team Baker so that we can take a look. We'll see if it's better tomorrow. So we'll see if it's better tomorrow. Let's answer some questions and some super chats, and then we will be back tomorrow. I have a lot of you are like, it was so hard to read. Fair enough. We'll see what we can do, because it came through on mine just fine. So it was really hard for me to see, but we have had a lot of feedback of like, this did not work well today. Sorry about that. It's frustrating. When the tech doesn't work, it makes me want to hurl things. I almost defenestrated my computer out the window very late last night, and things still aren't working well. So yay for us. The tech is teching. Love my Ponards. Thank you for the 5 gifted memberships. Very much appreciated. Katie said, my sister Maggie and I adore you. Much love. Hello, Katie and Maggie. Good to see you. Thank you. I know. Ellie's like, back to Utah. I love it. Nancy D, if you please. Hey, I love the reference that I could member for 9 months. I could have had a baby, but this is better. I'm too old for the baby stuff. Look, other people's babies at this point. I'm here for it but I'm all emo. I can't start talking about it or I'll just start to cry. Emily, all the crying. Yeah, all the crying. I'll just start to cry. I will. I'll just start to cry. But we'll see. Cindy said, got accepted to college for paralegal at 40. Cindy, that's amazing. Look, I didn't really start doing YouTube stuff until my 40s because you know what? There was a long career ahead of that led us to here, and now we're here. I love it. It is never too late to pursue the things that you enjoy, Law Nerds. Just, we only get this, it depends on your belief system, but while we are here, I very much believe we try to make the best of the time that we have because we never know. And I'm going to get all emo again. So I'm going to breathe. We're going to enjoy each day. We're going to just enjoy each day and be glad we get to be here together. And also be glad that we get to look. It is always a heavy lift to cover family law cases because there is so much not of did a person commit a crime. It is a different standard than that in family law for restraining orders, but you were trying to navigate a very difficult and toxic situation with a lot of opposing perspectives and a lot of behavior that is harmful. And so in trying to navigate that, it is difficult to navigate, but also it is something we do not cover often. And it is something that a lot of people are going to have more connection with in the court system with family law than with anything else that we cover. And with things like temporary restraining orders, temporary protective orders, and the headlines on this case and others are so often so wrong that being in the room where it happens was important to me, or being in the courtroom where it happens, because we can navigate A, what's happening in court, and B, what the facts are, because I'm sure there will be wildness. My Sky said Mythbusters. Griffin has started Mythbusters back from the beginning and is loving it. Is absolutely loving it. Love Mythbusters. Teaspoon of Splenda said, I love that you used defenestrated. The other day, maybe it was last night, I don't remember. Time is a construct. Somebody was asking in the comments what yeet meant. And I was like, basically defenestrate. I mean, yeet is basically hurl. It is to hurl, not necessarily out of a window, but just to hurl quickly. We are going to yeet. So yeet is just the modern defenestrate in my mind. That's where it's at. Ashley Party of One said, thank you for covering this. The misinformation spreading on TikTok is driving me crazy. And I'm starting to look cray in the comments like EDB is a lawyer. Listen to an actual lawyer instead of a random TikToker. I feel like an EDB advocate on TikTok. I am not on TikTok a lot. And I am sure there is very much a insert name of party is in the wrong because. However, all of that aside, what is happening in court is finite. But when it comes to the video on TMZ, I'm here for someone to share with me another option. I will wait. Because Dakota sold that video to TMZ, in my opinion, because that is the only way they could watermark it, have copyrights in it. And I did a whole podcast episode about it. The court can't release it. The DAs can't release it. The police can't release it. Taylor didn't release it. Who would they buy the copyright from? And we know that because we saw Morgan Tremaine, Spicy Draco, explain to us how TMZ works. We have more knowledge than we did prior to Depp v. Heard because of that testimony. And so we can look at what Morgan testified to, look at the situation, look at the options and go, well, okay. So, and I have not seen anything else. However, does that justify Taylor's behavior? No. Does it excuse her behavior? No. Does it make it okay? No. No, not okay. However, also not okay. Different types of not okay. Both can be true. All can be true. This is going to be a very difficult case of all of this is not okay. And the court is going to have to navigate all of this is not okay. And we're going to have to navigate the lawyers with a bunch of fact checking being like, no. Oh boy. And Taylor's lawyer starting out with the he shouldn't have acted this way is going to bite him in the ass. Just not a good way to argue. Not a good way to argue. Not gonna help. Not gonna help at all. So that is it's going to be tough. Let's see. Susan said, I did not recognize any of the legal players in this hearing, but having had time in Utah family court, it was pretty civilized. Oh, it was definitely not the wildest day in family court. It only feels wild if you've never seen family court before. It was not a wild day in family court. which is why I'm so frustrated about like the own goal errors that didn't need to happen. So that's frustrating to see. Like, why are we doing that? Why are we saying that nobody's being charged when that's not accurate? Like, that hasn't been decided yet. Raven's Light said, tomorrow is my birthday. EDB in chat, happy early birthday. We will be live tomorrow. A lot of you are giving me heads up about the app. Nishay, I got P.O. Box. I have a pile of P.O. Box, so it should be in there with all of the P.O. Box stuff. I have not opened P.O. Box in way too long, but I have everything that has been sent recently there. B. Rose, thank you so much. I'm going to see if there are any other questions. Lindsay, this is a great question, and it's hard to have some of the nuanced conversations around production and ethics in production when you are dealing with people harming each other. Lindsay said not to absolve the individuals of responsibility in cases like this, but I wonder when production companies will also start to be held responsible. It's a question and it's a conversation, because I understand that the argument goes, they don't have to choose to film. The other side of that argument is that they have now oriented their life around this job. And I do think being on reality TV is something that is very hard for people to walk away from, even when it is not healthy for them. And there is a component to it that people talk about not being able to walk away from. And we've seen people talk about that when they've left reality TV and then come back and they're like, this was destroying me, but I can't be without it. And we see people talk about reality in that way time and time again. And so when your money is wrapped up in all of this, it becomes a very difficult dynamic. Yes, people have agency, but also their money and their family is all wrapped up into this. And that's why we're seeing lawsuits that we need to peek back in on. But that's why we're seeing and still following the Scandival lawsuit, and we're following the Leah McSweeney lawsuit. There are these lawsuits against networks and production that are starting, and I think it will start to change maybe production vetting. And the thing that will change production first, again, this is not an area I've ever worked in, but I would guess logically that the way this will change production is when it starts really fucking up the money. And this has fucked up the money. So production's going to have to shift the way that they vet and navigate so that they don't fuck up the money. So you just follow the money. This is going to fuck up the money. Yeah. And so production's going to have to figure that out. Trisha asked about custody. Dakota has full custody temporarily with now visitation, supervised visitation. My brain cannot read the letters. I am very sorry. But the comment resonates very well. I'm glad the commissioner is privy to the nuances of DV. Yes, and this is a commissioner who sits in family court. So this is somebody who is well, I would imagine, goes to a lot of trainings, but also sees this all the time. Like all the time. Red Thread Mama said, I volunteer as a court-appointed special advocate in Iowa for the foster system, talking with them, writing reports, going to court. No one wins in the situation. Damage is done regardless of outcome. It is sadly the reality. And I think the hard part in the court system is that you can't fix it. Like, they can't undo the fact that the video that Dakota, in my opinion, released to TMZ, which is not Dakota and Taylor's child together that's in that video. This is before they had their child together. It's Taylor's child from her prior marriage, but that will never go away. That video being out there, people having seen it, that will never go away. In addition to the other things that the children have seen and heard and experienced that will never go away, and what the parties have experienced that will continue to carry out in patterns for them that they will have to do quite a lot of work on. I don't think any of them can do that work while they are still together or talking or in the same room or possibly in the same state, which makes co-parenting difficult. They need to just, which is hard, but I do like what we've seen from Commissioner M. I do. Commissioner M was like, let us be grounded. Let us be factual. Let us keep focused on what we need to do today. And I appreciate it. So, let's see. Do you think this couple are hampered by celebrity? I don't know them well enough. I think, Emma, one of the problems for Dakota and Taylor, again, as a complete outsider who watches reality TV, I think one of the things is that because their storylines are all centered around one another, it has kept forcing them back together and forcing them back into contact with one another in a way that is not good for either of them. And I think that's filming. I don't think that's just them being known. I don't know if Taylor was known on TikTok, if she would have kept in this cycle with Dakota and vice versa. But when they are both filming together and they are getting paid to film together and they keep getting pulled back into filming together, that the filming is more the issue for me. And that might be a distinction without a difference, but the filming is just, it keeps pulling them back together. And that's hard. I think for both of them. So RK, I think the court pointed this out too. RK said in a super chat, not a Taylor apologist, she has responsibility, but I really feel like the person ready to record is setting up a situation looking for a reaction. The court touched on that a couple times, that both things can be true. He can be trying to get a reaction and she can be giving a reaction, and both of those things are true. And that the court touched on being concerning, and the guardian ad litem touched on being concerning, that they were concerned about both parties' parts in it. I didn't hear anyone in court today, other than the lawyers for their own clients, say that, well, I can rephrase that better. The court and the guardian ad litem both acknowledged that there was concern with regard to both parties. However, the procedural posture of the case is that Taylor filed the restraining order, not Taylor, is that Dakota filed the restraining order against Taylor, and those initial orders were made because of the restraining order he filed. So that's the procedural posture they're in, but that doesn't change that there were concerns with regard to both parents. Hopefully that makes sense. But again, Taylor, the guardian ad litem said it better than I will. Taylor has a lot to lose in the criminal system and with her kid by being reactive in that way to Dakota. And that is something the guardian ad litem had concerns about. And those are fair concerns. So it is that part of that is how much consequence there is for her because of that case and her not being able to pick a different door when it comes to Dakota. And it's hard to watch it play out. Sandy K said, I thought Taylor's lawyer said they weren't pressing charges. Taylor's lawyer did say that. Taylor's lawyer said that's what they learned from police. And the guardian ad litem said, challenge, that's not accurate. And again, on that, I side with the guardian ad litem. That is the groundedness in the room. And we hadn't seen anyone file in court saying they're not seeking charges, and the DA's office makes those decisions. Music to My Soul said, what is your take on ex parte TROs being used for temporary custody orders? There was room for concern. I have concerns after I don't remember which KF case, because there's potential for misuse. There is potential for misuse, but the goal is that it is incredibly temporary. The goal is that it tries to put a roadblock to stop a situation. Again, paper can only do so much, but it also sets up a court process for a hearing to happen so that intervention can happen. And in this case, it was filed, when did he file it? On the 19th, March 19th, and they were able to get a hearing by April 7th. So it is something that the court is aware can be gamified. And the court noted that in saying, I am aware that people will do this to get a benefit in a custody case. You're not going to, play tricks with the court. And it is always meant to be temporary before there's a hearing to change it to a permanent situation. And the default will always go back to what the child custody order is. And this judge has both of them. So, yeah. But yes, there is potential for that. The thing is that courts are, not all courts. Courts can be fairly attuned. I appreciate when they have more dedicated family law courts because the judges see it instead of seeing it with everything else. Journey with Janice asks, can the person who leaked the documents to TMZ get in trouble by the court? Not if the documents are from the party that sealed them, because they chose to seal them. So there's not much the court can do with that because they chose to seal them. So you're sharing your own documents. Now, if the other party had sealed them, not that it doesn't happen, there's a little bit more room for it. And there's a little bit more process if it came from inside the courts, like someone from the courts. But we'll see. So let's see. They could have, let's see. Krista said, dude ran out and got an RO instead of going through family court. In this case, they are in family court and they had an agreement in family court. So, let's see. AJ said Taylor's posting, was she ordered not to? No, she wasn't ordered not to post. Nobody in that was ordered not to post. It was a public hearing, which not all family courts are. It was a public hearing on a restraining order. It was, the court documents are sealed, but there's no non-dissemination order. So yeah, people can post. Now, is it ill-advised? It depends on what's said. I scratched myself. My skin is so reactive. I scratched myself. That's me. But yes, the Guardian Ad Litem, I think, was incredibly grounded. And did you notice that the Guardian Ad Litem just stuck to the issue at hand? This is the issue. These are my concerns. These are why they're my concerns. This is what backs up those concerns. This is what I think. And that's it. So, yeah, again, with the no posting, no one was ordered not to. It's very hard when your livelihood is tied up in all of this, though I would hope with multiple seasons filmed and brand deals and whatever, there would be enough savings to say, I'm going to take 3 months off of social media. I'll be back. One would hope. But I also understand when people feel like they're being attacked, they are going to just do all the things. So we'll see. All right. With that, Law Nerds, we will be back tomorrow. I can't tell you what we're covering yet tomorrow because I have not decided. I am of multiple minds. I have gotten a lot of requests for a lot of different things. I am in the middle of one of the longest court orders I have ever read. Just ever. Oh, Crystal, no, it's okay. No confusion. My brain does not always connect all of the things, which is, again, it's an ADHD brain. Sometimes I'm very on it. Sometimes I'm like, what? No worries at all. Sometimes I'm quicker than others. Tomorrow we will not be in Utah. We will be elsewhere. I just haven't figured out exactly where we're going to go yet tomorrow. I'll figure it out at some point. But I am in the middle of a very long court order in Lively Baldoni, I feel like I am back in contract law in my 1L. It is one of the most extensive court orders I have tried to navigate. It is thorough. We're probably not going to do that on a live stream. I am still trying to unwind what's going on with the Corey Richins civil stuff. And then there were some appeals that were happening that I've gotten lots of questions about. That's going to be on a podcast because it's not a case I'm going to cover live. But I've gotten a lot of questions. Hopefully I can answer those. But the Lively Baldoni order is it's incredibly long. And then we have a bunch of Karen Reed civil stuff, a bunch of it that I'm trying to catch up on. So we have lots on the docket, some new, some not new, and a lot of reading for EDB because I would like to give you the more nuanced legal answer, but it's also quite a lot to parse through. I just need time to read it. And I put all of the work down this weekend and spent time with the family, which was nice. But now I feel behind. It's always a push-pull. I'm like, that was lovely. Oh, there's so much. There's so much. There is, Sophie, there is so much misunderstanding. And then there's some spinning. There's some spinning going on with the court's order. So I would love to be able to go through it all and be like, this is what the judge said. Period. But I'm not all the way through it yet. So I'm working on it. So I will keep you posted on tomorrow. We're working on what's going on with the app. Team Baker has it. Team Baker has it all queued up. And with the rest of it, I will see you tomorrow. So stay tuned. What adventures might we have tomorrow? We'll see. Thank you for hanging in there. Cases where it's like, oh, all of this is a mess are hard. Thank you for navigating. And I appreciate it. I love this. Doctor Who's like, ever thought about getting a paralegal? I am of multiple minds. And before I go down the ADHD rabbit hole, I will just say that I will end up doing all of it myself because I need to read everything to see what else I want to explore or what other questions I have. Otherwise, I can't answer them on live stream because I need to process the information for me before I can help process it together because that's a lot of what we do. So then I would get to questions and be like, I don't know. And sometimes that's just the way it is. But I like to know and I endeavor to know. So sometimes I just need my brain to noodle through it. This one's just a little bit of a longer one. But yes, it's come up, but not quite in that way because I need to process it, if that makes sense. Law nerds, it's great to see you. I know court was tough. It's a case I'm curious about. It's a case I see the media get wrong a lot. And hopefully it helps having a nuanced conversation about what we're seeing in court, what's actually happening in court, and what we're watching in court. So I will see you guys back here tomorrow. Make sure you have the Law Nerd app. We are working on all of that, and we're continuing to do the tech things. So I will see you guys tomorrow. Thank you, Law Nerds. You are the best. Have a good day. Bye, everybody. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.